you mentioned.
Item number 1.
May it please.
Yes, Mr. Sangwa.
Lordship, Lordship, I have received the objection petition filed by
Yes.
my learned friend.
Preliminary issue.
May I reply to the...
Let me.
Yes.
This learned friend has firstly preliminary objection. He has quoted that Rule 10, specifically the D section.
Rule 10 of what?
Rule Meghalaya High Court Rule 10, page D.
Rule 10 of?
Rule 10, C, Lordship. Number 1, C. That Rule 10.
What is Rule 10 C?
No, part 1, preliminary objection, not Rule 10. Page
Rule 10 of what?
Of
page
the
191
of the affidavit.
No, I'm just taking from there because in his affidavit he has make a mention.
Be clear.
Lordship.
Now listen.
Lordship.
Your file is PL, correct?
Lordship.
What is the objection to the
his
what
objection
are the main objections to
The
maintainability?
main objection is that
He will start because he's
Lordship.
objecting
Yes,
to your
Lordship.
maintainability. Yes.
Now, number one objection, my lord, is that he is a former MLA. And what he did, my lord,
Being former MLA, that means
of the area, my lord, and it is a politically motivated petition. Why I say so, my lord, for the and publicity oriented, my lord. What has happened in this case, my lord? There are two facts which your lordship may take into account. One is that before the PIL was listed, my lord, it was leaked to the Ceylon Times, and it was published.
before it was filed.
Before it was filed, my lord. I have placed that newspaper cutting. Second requirement of law, which your lordship has laid down in the rule, is that the petitioner has to give representation to the government as to the allegation, or to the government or Justice Kathaki, my lord. What is his allegation, my lord? What he did in the PIL, that he doctored two documents. One, my lord, is the report. One is the report.
Doctored two documents.
Documents, my lord. Why do
have you taken action against him for that?
And now, because the matter is, we will take action, my lord. It is a all illegal thing, which is how it.
But that is patent.
And 340 is a case of 340, my lord. 340 CRPC.
Is it patent on the face of the record itself?
Patent, your lord. So kindly see that.
That's been doctored. Anyway, continue.
I will show that, my lord. What has happened, that DMR gave a report to the state government with regard to inventorized coal, that this much inventorized coal is required to be auctioned by Coal India. That is the report of the DMR, my lord. Based on the DMR report, what my friend says, that DMR has indicated X quantity of coal, but you have auctioned more quantity of coal, and you have indicated in your report that the coal is not there in South Garo Hills. What he did, my lord, in Annexure 7, it is a extract of the report of Justice Kathaki. But what is Justice Kathaki's one page has been photocopied, annexed here, and saying that this is the report of Government of Meghalaya Mining Department, my lord. If I can show from the...
Only continue, then that's okay.
One
point on the mainly
and then he says that...
He publicized his all
publicity and
publicity and Times.
And then violation of rules, because your lordship
has... of the PIL rules.
Because without that he could not have filed the representation. Third, my lord, entire PIL, if your lordship would see, that he himself says that he is not clear as to what is happening. Now, if he is not clear whether he can approach this honorable court and abuse the process of law and go and publish in the newspaper saying that everything is wrong in the auction by the CIL under the aegis of Justice Kathaki, my lord. I put a question, because if we entertain all these kind of PIL, my lord, on who are having vested interest, and I will show from merit first, from the merit, my lord. Kindly see the PIL. Kindly see the PIL, my lord. These kind of PILs, they are...
Mr. Sama, you file a short reply. Otherwise, I think...
I'll file it.
Otherwise, if whatever submissions made by the Learned Advocate General is correct, that means...
Lordship, I will file it.
Number one question which comes to mind after submissions, that regarding these discrepancies which you say has happened, did you go to the Justice Kathaki single member committee to make any complaint?
No.
I did not go, Lordship. No, Lordship. I did not go. But
did you approach him or not? He is there, single member committee, and he's open to all, to all complaints that might be there regarding transportation and auction.
that
he is not interested.
Lordship, may I say, we have approached, but that is not this PIL was specifically only on. We are not entitled this one. We have specifically mentioned.
Have you approached? Have you exhausted all other remedy? Have you gone to the?
We have approached, but not only to that question which we have raised.
It's a patent lie.
One thing is that why we asking for a reply from you? Is that because if the allegations of doctoring or fabricating documents are correct, that's very serious and we have to take action.
Lordship.
I file a short reply, we'll take it after. But if it's true, we cannot refute it, you'll suffer heavy cost.
Lordship, I will file a short reply.
And you cannot withdraw the PIL just like on a whim.
Lordship, I'm ready to reply. I'll file in a short reply.
But if it's found that the doctoring is...
Let me finish. Lordship, I bow down. Lordship, yes, I'll file it.
There will be heavy cost in.
Lordship, I will satisfy. I'm satisfied because he whatever making submission is just. I strongly deny. I will satisfy this court.
To objections raised by the respondents as to the maintainability of the instant public interest litigation petition on various grounds. Stop. Mr. P.T. Sangma, learned counsel for the petitioner, prays will have to file a reply to the same. Stop. Next part. A reply is permitted at this stage inasmuch as there are serious allegations have been made as to the conduct of petitioner, especially in what do you say in doctoring
in attributing a document to the government which is nothing but
attributing a document to the government which is nothing but
part of the report, extracted report.
Now we will write down in Pune.
A reply is permitted at this stage in as much as there are serious allegations have been made as to the conduct of the petitioner, especially
in the furnishing of documents which have been annexed to the PIL. Yes.
And PIL rules have also not been followed.
I will satisfy, Lordship. I'm ready. I'll file the next day.
Otherwise, you'll suffer.
Lordship.
And you can't withdraw PILs like that.
No, I'm not going to withdraw. I'm not going to withdraw. Lordship, I'm ready to answer all the whatever my learned friend has said.
They should have filed a reply by today. When did you receive the copy?
Because recently only I was out of station, Lordship. Because I was taken on leave, I was out of station. I went to Garo Hills. I received only yesterday because my colleagues, they have received. Yesterday only I read through, but Lordship, I didn't get time to because only one day was, yes. Lordship. Much blessed, Lordship.
Yes. What is this?
The traffic PIL, my friend has sought time for filing.
My Lord, I filed the reply yesterday. May prepare may come after vacation and consider. I filed the application whether if AG is ready, my
Lord. You think the traffic will improve after vacations?
It will not improve. It will not improve. I filed along with the documents, along with the photo also. They made a promise 2022 that they will complete measure within 6 months, 7 months.
You got a reply?
I haven't received it.
I think we have served.
I don't know, probably.
We have served. On 15 we have filed, madam. Otherwise we are not allowed to file. Therefore I pray if he is yet to receive, madam may come after
15 is last Friday.
Yes,
okay,
we have
Mr. H.R. Chanreso, Senior Counsel, submits the reply to the status report. Little status report since status report has since been filed. Stop. Then it's like paragraphs pray the matter be taken up after vacations for consideration. List accordingly and so on.
Item number 3.
May it please, Your Lordship.
Yes.
My Lord, this is the 19th report of Justice Kataki, my Lord.
What do you have to say?
Your Lordship, if I take Your Lordship to the report, my Lord, there are two parts of the report. Your Lordship will kindly see the report. What Justice Kataki has said, my Lord, particularly that this Don Bosco coal was not part of the earlier inventorized coal. Because there are two reports which were placed before. One under the aegis of Justice, under the then Chief Secretary, Mr. Kofa, my Lord. And then thereafter there is a second report in which the coal was found. And Justice Kataki has given certain findings. If I take Your Lordship to, my Lord, those findings so that Justice Kataki has written the finding that it may not be part of inventorized coal. That is the finding. Police has registered the FIR, my lord. We have made the report of Justice Kataki as part of the report of the FIR, my lord, and we are investigating the matter. And certain queries have been asked by Justice Kataki in 19th report, if your lord kindly see.
Page
4, my lord, of the report, 3.1.
Observations.
Yes, as observation. Availability of coal dumps behind Don Bosco College, Bindihati is not in dispute. Deputy Commissioner East Jantia Hill has taken a stand that coal found behind the college being part of already inventorized coal is not illegal. Deputy Commissioner has also taken a stand that possibility of mixing of some fresh coal with old cannot be ruled out. During the interactive meeting held on 8 December, Deputy Commissioner, however, stated there was no transportation of coal stock to designated depot pursuant to transit pass issued by Transportation Department, my lord. After taking note this, my lord, if your lordship will see 3.3.
Notice the other part.
Yes, your lordship, I will take it. I will read whole. Which is the presence of fresh tire marks of heavy vehicle, which is an admitted position of the fact, coupled with the stand of Deputy Commissioner about the possibility of transportation of fresh coal to that area, established fresh transportation of illegally mined coal and from coal dumps found behind Don Bosco College Bay. Deputy Commissioner East Jantia Hill in the report has also mentioned the NGT serial number 1049 to establish that coal found behind the Don Bosco coal is part of already inventorized coal and not freshly mined coal. It reveals from the material made available to the committee by the state government as well as Deputy Commissioner East Jantia Hill that pursuant to order passed by the Honorable National Green Tribunal on 1st August 2014 in OA number 73 of 2014, a process of assessment of quantity of coal available at that point of time, which was after imposition of ban on illegal mining activities of NGT, was initiated by a committee constituted by NGT consisting of Sri K.S. Kropa, Additional Chief Secretary to the Government of Meghalaya as the chairman, and Sri M.S. Rao, Principal Secretary to the Government of Meghalaya as member of convener, and a consolidated statement of assessment of coal as on 30th August 2014 was prepared, along with data sheet of coal inventory in respect of the concerned district, including East Jantia Hill district, stating therein that serial number, name of the mine, on a location, GPS coordinates, declared quantity and quantity assessed by the committee, which was annexed as Annexure 1 to the guideline prepared by the said committee for transportation of extracted coal. The said assessment in respect of East Jantia Hill contained an entry at 10. Yes, my lord. I will just, your lordship, kindly mark the date, my lord. This was date on 1st August 2014. This is on 1st August 2014, it was nil, my lord.
So he declared coal which did not exist.
It was on 1st August 2014, my lord, it was nil, my lord.
And finally it came out magically.
No, your lordship, what has happened that then again in 2018, next paragraph, your lordship will kindly see, 3 point, Justice Kataki has noted all these aspects, my lord. It appears from the said assessment made by the said committee, which already made available in volume 2 of the preliminary report submitted to the committee before this court, that said committee had verified the quantity of coal as declared by various mine owner depot, and whenever they could find any quantity of coal against declared, the GPS coordinates have been mentioned, and wherever due to any reason that GPS could not be read but the coal was found, same has been mentioned. The committee in the said assessment naturally did not mention GPS coordinates. Your lordship may kindly mark this aspect. When no coal is found against the declared quantity by any mine owner, depot owner. The committee having not found any coal at the quantity of 5,000 metric ton declared by Sri Mul simply, no coordinates have been mentioned. In the column of assessment quality, it has been mentioned that there is no coal available, my lord. And then 3.5, my lord. Kindly see, surprisingly, based on the application filed by Sri Mul Simply and others in the year 2018, this which was the previous one, my lord, was of 2014, 14 August 2014.
So the coal appeared magically.
In 2018, coal was there, my lord. 2018.
Magically it came out.
No, your lordship, what has happened, my lord? If I can show paragraph 188, because this was the issue before Supreme Court, whether what will happen to the coal which has appeared from 2014 to 2018, and Supreme Court said that.
But one thing, Mr. R.K. Jal, the fact remains that this coal is not the same coordinates.
No, your lordship, coordinate also is, kindly see the paragraph. It is also clear from here, my lord. That coordinate aspect is also clear, my lord. Your lordship will see, a fresh exercise was carried out by then Deputy Commissioner of East Jantia Hill in 2018 about the existence of coal extracted prior to imposition of ban in 2000. wherein it was found that Mul simply had 4,800 metric ton against the declared quantity of 5,000 metric ton against the coordinates. Your Lordship may kindly mark this coordinate 25.33249 and 92 point so and so. What has happened, my lord? If your Lordship will see coordinate last two digit 49 and 47, there is some discrepancy in very 10 meters discrepancy in the coordinate, my lord. No plausible explanation could be given as to how and in what manner the then Deputy Commissioner could assess the quantity of coal belonging to Mul simply stated to be extracted prior to imposition of ban of NGT in 2014 after 4 years in 2018. Nothing could also be placed on record whether any attempt was made to whether said quantity was freshly extracted or by Mul simply in the year 2018, my lord. I take it, my lord, that the coal was extracted in 2018 after the ban of NGT in August 2014, my lord. But the Honorable Supreme Court in the judgment of date 3rd July 2019, because Justice Kataki estimated about 23 lakh metric ton of coal, state based on these report, state gave the affidavit of 31 lakh metric ton, my lord. And the Honorable Supreme Court in paragraph 188, if I can show that paragraph, my lord,
yes,
of the judgment of the Honorable Supreme Court in all the Masa, my lord.
We're reading.
I'm sorry, your Lordship may have this judgment, my lord, the judgment of all the Masa, where this issue is there, my lord. Precisely this issue was raised. And your Lordship will read the paragraph 188 of all the Masa judgment, my lord. All the Masa judgment. Your Lordship has all the Masa judgment. This is the citation is 2019 8 SCC 177. Because this was the precise issue which was there before Justice Honorable Supreme Court and Justice Kataki report based on 2014, because there are two dates which are coming before your Lordship's kind consideration. One is the coal which has been (2019) 8 SCC 177.
Paragraph
188. The state of Meghalaya, your Lordship, paragraph 188, page 272, my lord.
Yes.
188. The state of Meghalaya has filed additional affidavit dated 6 April 2019 of the Commissioner Secretary to the Government of Meghalaya, Mining and Geology Department, where details of assessment made by committee appointed by state government have been brought on record. In the affidavit, it has also been stated that a technical committee was also constituted to perform the verification of assessment made by Deputy Commissioner of respective district. As per affidavit, assessment of extracted coal stock is above in 4 districts is 32,56,751, whereas in report submitted by Justice Kataki committee, the said figure in above 4 districts is 23,25,663, my lord. And then your Lordship will see this aspect has been dealt in paragraph 190. Your Lordship will see the paragraph 190. We accept the suggestion of learned amicus curiae. The entire extracted coal, your Lordship, entire extracted coal lying at various depots be directed to be taken over by Coal India, Government of India and unit who may dispose of the same as per normal method of disposal and proceeds to be distributed as per direction issued by this court hereinafter. NGT has already directed that for all extracted coal lying at different places, it is the state which is the receiver cum custodian of coal. State having carried out the assessment of coal lying in aforesaid 4 districts, including details of quantities and details of owners being available with it, it may ensure that entire coal is handed over to Coal India as per mode and manner of the formulated by Kataki committee in consultation with officers of Coal India and the state government. So the 3rd July, my lord, whatever affidavit was filed on 9th April 2019, my lord, that has been taken into consideration because Justice Kataki said figure which is there is 23 lakh rupees state. So the cut-off date is not the order of in my humble submission, cut-off date is
So you
not.
mean to say that just on technicality that, that might have been mined after 2014, this coal was always there?
Yeah, the coal, your lordships, the affidavit is also there, that entry is also there, my lord. So coal is there, my lord. And I am not saying that if there is a freshly mined coal, FIR has been registered, my lord. If the police has taken the entire report as part of the FIR, investigation is going on.
What else you want to say from the report?
And then, therefore, my lord, the notices have been issued to the accused. Investigation is going on, my lord, and your lordship's finding on this issue in the FIR, which is pending and criminal investigation, will place the report entire investigation, my lord, regarding this. But what I was trying to submit, that there are two, Justice Kataki has taken the cut-off date as August 2014, whereas Honorable Supreme Court has taken the cut-off date as 9th April 2019, my lord. And your lordship will recall that in the larger picture, my lord, this coal is not mined as per MMDR Act. And the Honorable Supreme Court could have, my lord, because if it is not mined under MMDR Act, the state is entitled to seize the entire coal as NGT has and take, but still Supreme Court said you auction it and give it money back to the coal owner, because there the Honorable Supreme Court realized that the past, the legacy which we are dealing with, my lord, and we are trying to streamline the thing. We are at the the light is at the end of the tunnel, my lord, because if the entire coal is shifted to coal depot,
will the auction be finished by December?
Your lordship, the 5 lakh has been finished on 3rd November. Only 5,50,000 coal is lying outside.
That was the submission made last occasion.
It was the schedule was this much. This was only in respect of 30 lakh. But only problem what we are facing, my lord, is that we have auctioned the coal on. The Coal India has auctioned the coal on 3rd November. Now those coal have to be lifted from depot, and if we transport the entire coal from the that is remaining balance coal of about 5 lakh to the depot, there will be, if any coal is found like this, that will be illegal. So therefore, I was praying, my lord, kindly give me.
I was expecting at least by today to have some reply to it. That's why the last day, without even
your lordship sought clarification. I will
without even examining the report, it was received just after the matter was over.
Yes, lord.
Which indicated in the order.
Yes, yes.
The thing is that we expected some sort of reply.
I will file, my lord. I will file with investigation, my lord. Investigation. I will place that investigation report also, my lord.
But I think the materials that are here very disturbing.
And on GPS coordinates also, I will place that. I have got the photographs of GPS coordinates, so will show that it is close to each other in GPS coordinates also, my lord.
And SP said that he's taken all steps to arrest the illegal movement and extraction of coal.
Yes, your lordship.
I mean, he's failed his duty completely.
Your lordship, we have in fact.
If you look at the report.
If your lordship, I can show this the GPS coordinates by investigating officer and this one here. This one.
See, Mr. R.K. General, we're going by the report of his on the ground report. Justice Kataki went on the ground.
But your lordship would appreciate that one thing is there, that the Justice Kataki went to the entire whole district and at one place only he found coal, my lord. I said, I'm not saying that there is no illegal coal. I
said that his report also that you have not explained to the other dumps that are present, and especially regarding the small mines that start operating again. He said that these huts are being built by these workers. That means there is illegal extraction still going on, and notwithstanding anything else, very unfortunate, but that means the law enforcement machinery has failed in this East Jayant Hills.
I'll satisfy your lordship. Kindly give me opportunity to file reply on this aspect also, my lord. Because
it has failed, I mean, that's the thing. No, the report is very clear. It's unambiguous because it addresses only the very fact about the report. Just
is based on two facts, my lord.
I'm afraid.
Your lordship,
not forget about that 19 or 14 cutoff date, but
report's basis is, my lord, Moose simply is claiming to be owner of the coal of 4,800 metric ton. Justice Kataki goes by the previous report of the Deputy Commissioner. So Moose simply is claiming that I am the owner. Coal is there, my lord. Now we are investigating whether it is a freshly mined coal, new coal, my lord. And the coal is there on the site only, my lord. If your lordship would see from that perspective angle, my lord, I would urge your lordship to see, and there is no difference in the coordinates also, my lord. If I can show the coordinates,
I will place
that the photograph also with my affidavit, my lord.
Finding.
I'll place the photograph also.
Where does he say? Page 7, yes. 3.8.
Yes, Your Lordship.
Yes. Yes.
Your Lordship, kindly see the difference in the coordinates. It's a minuscule difference, my Lord. Difference is hardly any, my Lord. The FIR describes the area, my Lord. It's FIR because Justice Kataki said that it is lying behind Don Bosco. FIR describes the area.
See, read part 2.
Yes, Your Lordship. Roman 2.
Pardon me. Yes, 38, 3.82.
A2. Moreover, IO of Khairyat PS case, by his communication dated, has also informed Deputy Commissioner East Jantia Hill that during the it found that coal dumps as per coordinates mentioned in FIR are not matching. The physical inspection of the coal dump found behind Don Bosco and correct coordinates in respect of coal dump. My Lord, the area was described. The person who noted down the coordinates was wrongly, and then coordinate found, my Lord, kindly see the coordinate by the investigating agency, because the complaint came, I can place that FIR, my Lord, complaint came describing the coal behind Don Bosco, but the person who was typing this, he wrongly mentioned coordinate.
Even then, see, the finding is that even whatever it is, this coal cannot be said to be the one that's inventorized even 2018.
Your Lordship, kindly see.
Going by argument
Your Lordship,
that, okay,
kindly see.
we'll not accept 2014 cut-off year. Well and good.
Your
We'll accept as 2014. And then 2018 is inventorized. That does not match that place.
Your Lordship will see the finding of the
Justice. Some orders.
Finding of Justice Kataki is, my Lord, that it is in 2018 inventorized coal. Justice Kataki is not accepting. Justice Kataki is saying that I will go by 2014 only, my Lord. Kindly see 3.6, my Lord, of the 3.6, my Lord. At pace, on the basis of such press assessment, an additional affidavit of 6 April 2019 was filed by State of Meghalaya and badge giving details of assessment made of the state inter alia stating out about the availability of so-and-so. In the said assessment, name of Sri Mul simply appears with extracted quantity of 4,800 metric tons.
Just now, para 188, it's just...
Yes, my Lord. Yes, and now, Your Lordship, kindly see, I'm just trying to take Your Lordship to the finding of Justice Kadaki in 3.7, my Lord, where the Honorable Supreme Court in para 186 of the judgment passed and batch accepted the suggestion of learned amicus, my Lord, that Your Lordship have seen 3.7. In view of the said position, the quantity of coal belonging to Sri Mul simply, which was found to be 4,800 in the year 2018, also needs to be put to auction by the Coal India Limited, of which the state government is the receiver custodian, and produced said coal still exists in coordinates mentioned in the subsequent assessment in 2018, my Lord. In the contention of that coal found behind is subsequently inventorized in 2000 is not acceptable for following reason. Justice Kataki has not accepted it of 2018, my Lord. It is part of the affidavit of state government, admittedly, my Lord.
Doesn't matter.
And
that is a lot of water under the bridge 5 years ago.
So, no, Your Lordship, kindly appreciate, my Lord, that the affidavit discloses it, my Lord. Supreme Court says that whatever coal is there at the site,
you put down whatever you have to say to state report. We will consider it, but for the time being, he calls for some orders.
Your Lordship, I was requesting, kindly give me time, my Lord, to place that.
Till tomorrow.
Your Lordship, it takes time because I have to place all the coordinates, recent investigation.
You place it, but for the time being, we are going to pass some orders.
Your Lordship, we are kindly see the constraint also.
Mr. Like that contempts hanging over the heads of.
Yes, Your Lordship, I bow down.
We are afraid that that this report is so and this report is significant.
And then Your Lordship will see what justice.
One particular point which has been addressed by Justice Kataki.
And the report, if Your Lordship will see, the investigation in PS case also, my Lord. The direction was issued, investigation in the said PS case needs to be expedited under supervision of senior gazetted police officer. Now SP has taken over the investigation in this matter, my Lord, as per recommendation of Justice Kataki, my Lord. As per recommendation of Justice Kataki, SP has taken over, my Lord. The investigation, my Lord.
Anything else?
The point is, my Lord, Your Lordship is, point is, my Lord, Your Lordship has seen, my Lord, this PIL has started since March.
See, the thing is that, you see, one
Your
thing...
Lordship knows, I can't say anything more. Lordship knows more than what is happening on the ground.
No, I don't know anything. Sitting here, we don't know anything. What we see is this, that no one's interested about the common interests of the state. See, we have people now who are working at cross purposes, against public interest, against public revenue, in a sense that coal is being smuggled out. And who's gaining?
No,
Other people from other states are gaining.
Yes, Your Lordship.
They're gaining. What are these people gaining who are digging the coal here at hole? How much are they getting per ton?
Nothing. They are the victim
It's being
of the system.
transported outside, and e-way bills are created outside. What happens is that other people are
They are
gaining.
victim of this
The
system.
entire public revenue system, the income the state should get
To the
is not coming.
Yes, sir.
How are you going to pay school teachers? How are you going to pay your district council people? How are you going to pay them if you allow this blatantly? And if
Your Lordship, it is part of inventorized coal, we are getting.
One thing, Ms. Hafiz, just listen. Why is this disturbing? Because the state players from the civil police who are at ground level, I feel roping in the chief secretariat has no meaning because they do not know the sitting secretariat. But people at ground level, you should understand also that what is public interest, what is sitting that chair for? What is in the chair for? It's in public interest. You are a servant of the public. You're a servant of public revenue. Now the thing is that if the state players also are hand and glove, seemingly, hand and glove, and to cause loss to the state to such an extent, everything is a national resource.
Yes, sir.
Whether it is coal, it is a national resource.
Yes,
and if in this way it's being, it's being like played around, like between many shades, many covers, what can the courts do? Courts can't go and sit out there and stand on a coal mine and see whether a transit a transit pass is genuine or is a duplicate.
Ultimately, it is for the state
dumps there in Paikan and in Dutnoy, they are coal coming from Meghalaya or they come from Assam or from Nagaland.
It is for the state authorities to enforce all this. It is for not for the court, not for me, not for.
It is not protecting the own.
Your Lordship, if I submit two things, my Lord, that Your Lordship has been, the sword has been hanging on the heads of these officers since.
And the sword has to fall.
No, Your Lordship, I'm just.
Fall from this bench.
I want submission, my Lord. It's hanging on their head, my Lord, but Your Lordship has been benevolent and kind because their time to time the complaints have been coming before Your Lordship, and Lordship has seen that there is a violation, but Your Lordship has been taking them task. Your Lordship have been cajoling them, pushing them to come to the
pushing them that the state players will understand that this matters. It concerns the state.
No, Your Lordship has been pushing them, and we are going to effect a change in the administration also. I assure, my Lord, we are going to effect a change in the administration very soon. We have taken note of these facts also.
You see, I tell you something. Why the entire dimension has changed? Why don't they agree to have a license mining? Because all the time before, what is happening? They were enjoying supernormal profits. There was no consideration for laborers' rights. There was no consideration for environment safeguards. There's supernormal profits in the sense that you invest 10 rupees, maybe you get 1,000 rupees.
Yes, that was happening.
They want the same status quo to continue. What's happening now is that there's exploitation going on, other people use supernormal profits.
Your Lordship, this can't go on, my Lord. What I was saying that only 5 lakh metric tons.
Those days are gone. Those days supernormal profits are gone. No, if you want to have a regime which is controlled, which is regulated, which will benefit the state.
And understand, my Lord, what has happened, my Lord, that entire coal, my Lord, is going to be transported to depot by December end. That is the timeline DMR has given, my Lord. So if any inch or any ounce of coal is found outside depot, my Lord, Your Lordship, take action against the officers because that will be there.
Action. The court type taking action.
I understand.
It's for the administration itself.
But at the same time, Your Lordship, kindly understand the difficulties because, for example, in East Jantia Hill, I am told, my Lord, there are total 125 police personnel are there, my Lord. Out of 100, we have got 4 police stations, and we have to and this is one of the longest highway where we have to maintain. And 24/7, we have to maintain Naka and check gate, my Lord. There will be some coal. There will be some coal, some issues, my Lord. I was praying that kindly consider these difficulties and give us opportunity to place all these material. I will place, my Lord. Kindly give me some time to place all these material also, my Lord.
We'll allow you, of course, we'll give ample opportunity, we'll allow you. Yes, I take down. In the case as this matter has come up today for consideration of the 19 interim report filed by the single member committee of Justice B.P. Kotaki, retired. Stop. Yes, stop. On 11/12/2023, after the matter had been taken up, a report was received. Stop. The same was circulated thereafter on the same day itself to all the parties. And it was understood that comments or replies on the same were to be furnished on the next date. Next paragraph. Contrary to submissions made by the respondents on 11/12/2023, the report of the 19 interim report of Justice B.P. Katoki has, however, spoken otherwise. The report, it may be added, is specific to the gold dumps found behind Don Bosco College, Bindi Hati. Stop. Behind and Bindi Hati. Stop. Queries were raised by the single member committee. And the stand of the Deputy Commissioner, East Jayanta Hills District, in respect of the coal dumps found behind and by the side of the Don Bosco College, Bindi Hati, were noted, apart from there being physical sittings on 8/12/2023. Stop. The report itself, having great significance, as it reflects the manner in which the district authorities, especially law enforcement, have conducted themselves. Is extremely relevant. As such, the observations made by a single member committee are reproduced herein below from 3.1. Stop. Next paragraph. The quote of the contention of Deputy Commissioner that the coal found behind Don Bosco College was not accepted by a single member committee, which has based its findings on facts. The same is with the stand taken by the district authorities on whether there was any transportation of coal stock to the designated depot pursuant to the transit passes that have been issued for transportation of inventoried coal. Next paragraph. Another alarming feature, which though not has not been dealt with in the report, but however touched upon, is with regard to the presence of other coal dumps found in Bindi Hati area by the side of National Highway. Stop. Next paragraph. Though it has been submitted and materials produced to show that investigations underway on and a case registered on 7/11/2023.
Yes, sir.
Tom, no?
Do it has been submitted and materials produced to show that investigation happened on the
Is underway.
and the case registered on
11/2023. In respect of the coal behind Moscow College, comma, the manner in which these incidents and issues keep cropping up.
8 November, my lord.
8/11.
8/11.
Cropping up have cast a severe doubt on the capabilities of the district authorities, especially the police, to stop such incidents. Stop. Next part. This goes of the view that though the Learned Advocate General has prayed for time to file a detailed reply to the 19 interim report, some directions are necessary to be issued at this stage. To stem the illegal activities that are continuing unabated. Stop. It is also to be noted that by previous orders of this court, excuse me, please order this court. The district authorities and the authorities concerned are liable for contempt. Which, however, till date, no, contempt. Which, if need be, will issue from this court. At this stage, however, just was talking. While allowing the state to file a reply to the 19th interim report, and not initiating contempt proceedings for the moment, on the failure of the Superintendent of Police as can be made out from the report, any other report, it is directed that he should be immediately transferred from his present post, and another competent officer be placed in charge of the district immediately. Stop. The Home Secretary, the Home Department, and the DGP to take immediate action in this regard. Stop. Yes, sir. See, he's failed his duty. He's come here and saying, and he's at the first point of contact. No point of issuing contempt against Chief Secretary. What do they know?
I understand. Yes, Your Lordship. If Your Lordship will see, the Justice Kataki in the last report has not come down heavily on SP, but he has not said anything.
He's a person that the DC is new. At least that's his only reprieve. Otherwise, he would have we're not issuing contempt right now. Yes. This is a matter for further consideration and for reply on also. Yes, next matter.
Item number 4.
Lord.
Yes. We will correct the order, but even Deputy Commissioner also is liable, but he has been there a few months, he doesn't know anything. From what I can gather, even the information he gave to just cut a case, he doesn't know here or there.
Please, Lordship. Lordship,
Yes.
we have filed the affidavit, my Lord.
When?
In fact, it was filed today morning, my Lord, because of some
Very
errors.
All PILs, no representation, no rules, nothing has been followed, my Lord. All they are same CO moto call, my Lord.
We'll throw all of them out.
Your Lordship, kindly do that, because they are all having vested interest. They file, they will take time. They are dealing
So in any case, what I'm
under
saying, my
the
Lord, is
table,
that
my
we have
Lord.
filed it.
Extortion is the
The-
name of
you
all
know
these
very
PIL. Extortion, I would say extortion, my Lord, extortion.
If my leniency is done, we have filed the affidavit, my Lord. I am only praying if it can be taken after vacation. In the meantime, we'll serve the copies to the Union and the state of Assam also. That we are yet to do, my Lord. But we have filed a proper affidavit in terms of...
Regarding what?
Again, coal, my Lord, coal auction, coal. South rules.
Yes.
And what they do, my Lord, if your Lordship will see PIL number,
Well, in fact, in this PIL, we have
PIL
even
number 4
produced-
and PIL number 8 by same person, 4 and 8. At serial number 4, my Lord, your
I
Lordship will
don't know
see.
Champa M. Sama. Is he a villain person here today?
He's not, my Lord.
He's never.
direct,
He's
we
never.
Can, if Lordship direct, we can call him, my Lord, to come. There's no difficulty in that.
Your Lordship, call them because
in fact, my lord, in this PIL we have time and again
Monu
produced
Kumar,
even
Your Lordship,
videos.
19-year-old,
The contempt.
20
We
years.
have a good mind, see. Let us see the faces of those public.
Very well, my lord. Lordship may pass the
Let's see the
direction. We'll
face,
call
you
them
know,
on the
that's
first
just-
day after vacation when the matter he'll be here, my lord.
No, we want vacation only.
Tomorrow?
Tomorrow.
If they're ready, my lord, because in the meantime we'll serve the copies to the union and the state of Assam and all, my lord.
What to do? Mr. S. Deb submits that the affidavit being filed in the course of the day.
No, we have
or
filed
been,
it,
been filed. But copies not furnished to other side. Rejoinder?
Rejoined, my lord.
Rejoinder has been filed. Or we'll take them all together, we'll throw all of them out. This is, if it's a contrived,
All of them, my lord, not a single one, my lord, except Sumoto.
We had filed the PIL way before the
Sumoto
Suo
only
Moto, my
for
lord.
implementing the orders of NGT.
We had
NGT.
in fact filed the PIL
And any,
even before the Suo Moto, my lord. I
deviation
don't
from
know
there,
why
the
these
scope
objections
being
are
at that.
coming.
And like I said earlier, we're looking at, at larger public interest. We can't let revenue leak like this. Let the proper system come in
No, in
place.
fact, if lordships go through the orders passed in this PIL itself, my lord, these objections will not hold any water anymore.
Very good.
I don't know why.
Just after vacation for hearing.
Obliged, my lord.
5.
You're an expert at slipping and sliding.
Even they are doing the same thing.
May I please, Your Lordship?
Yes, 1 second.
Lordship,
Assam
for the state
government.
of Assam, Mr. Dean
This is
Assam
PIL,
government.
my lord, regarding
And we are yet to receive the copy.
This number 9.
number 5, my lord.
Copy of
Number
what?
5, I am appearing for the petitioner, Your Lordship.
You
It is
kindly
in
furnish
respect-
copies of.
My Lord, I have not filed any. My Lord, okay.
5 you not received
So far-
copies.
5 is Salendra Kumar, my
Already
lord, this is
item number 4, my
co-government
lord,
plan.
PIL 8
4.
of 22.
In 4 we'll do it. No, we-
Yeah, they'll serve copies. Yes, 5. Next.
5 is co-government plan, my lord, which have been already been demolished. Matter is under stay from Supreme Court in item 5, my lord. The
Item
Honorable
5,
Supreme
absolutely.
Court has, because there were some directions, we have demolished about 36 co-government plans. Then thereafter they went to Supreme Court, and now I think matter is listed in March, in the Honorable 15th March or so.
We'll listen together with the other cases, see what comes up later on.
This Salendra Kumar, my lord, is useless PIL, again vested interest.
My Lord, I have a strong objection so far as, my Lord, that
Yes, Mr. Goyal.
adjective
Okay.
used by learned AG, my Lord. In this PIL, my Lord, this Honorable Court has passed order, because of this order passed by this Honorable Court, my Lord, 36 co-government plants have been demolished. And now my learned AG is using such type of adjective.
He is
My Lord,
having
I-
co-government plan. Salendra Kumar
My Lord,
did not disclose that he is having co-government plan, my lord. He is behind all these things. It's a private interest
Where is
litigation.
this co-government plan?
My Lord,
Yes, Your Lordship,
that
I have
am satisfied, my Lord.
kindly see the other
Incorrect
PIL
statement by my
where
Lord.
there is a
My Lord.
disclosure.
My Lord,
Yes.
I brought certain documents, my Lord, that will show my
9, Your Lordship,
incorrect-
kindly see serial number 9 where I have shown what is his interest.
My Lord, I
Serial
am
number
supposed
9.
to file, my Lord, affidavit rejoinder, my Lord, because of illness of petitioner, it could not be filed today, my Lord. My
10
I will
days they have taken, my Lord. 10
I will
days.
share my documents, my Lord.
10
I will
days.
share certain documents, my Lord, that will show, my Lord, the statement made by state is incorrect and state is relying on an objection given by, my Lord,
File
one of
them,
the
Mr. Goyal.
accused.
File them.
My Lord.
They have not filed and they will.
My
Their
Lord,
whole object is
I
to
have
take
already
time.
prepared it, my Lord, but because he
File
is
them.
73 years old, my Lord, he is Supreme Court
No,
court
no,
and people
he
today
is
could not
public
go.
spirited
supposed to file
citizen.
it, that's on
He is a
11 by
public
today.
spirited citizen.
My Lord,
Serial
it
number
is
9, Your
already
Lordship,
ready,
kindly
my Lord.
see.
It is handed over to him, but he could not go to Shillong, my Lord. He was supposed to go today, my Lord.
Okay, this all these matters.
Otherwise, my Lord, if
Yes. No point in just splitting hairs.
my Lord.
He is very successful.
about-
my lord. Last time he came out with the judgment of you in the matter.
My Lord, I am not.
And
my
he
Lord,
took
my
time, my
Lord.
lord. Now,
Using such type of
all
adjective
these
is
are
very
maneuvers.
easy. And
All these are
charge
maneuvers,
given
my
by
lord.
this Honorable Court against the state, my Lord.
All
Number
these
of
are
orders
maneuvers.
being passed against the state. My Lord, in that case, my learned friend
Okay.
should not make such type of objection, my Lord.
So we're short of time. We have only 2 days. This is after vacations. Okay, no time for
My lord.
this arguments. Yes, all these matters after same day. The criminal appeal was
So, Lordship, what I was praying, my lord, that these matters from can be detached, and your Lordship may deal with this chamber
Doesn't
too.
matter. We'll take it together. That's taken isolation as it is now. I'm not passing same orders. We just list it together, and the next day we'll deal with this other PILs.
One submission, my lord.
Yes.
Item 8, they were supposed to file the
We
affidavit.
have filed it. We have filed the reply. Affidavit is ready.
That Mr. Kinjing. Your criminal appeal matter will take it after the vacations. Yes.
This is the copy.
Mr. Mishra, sorry.
Well,
They're saying those who fight run away live to fight another day. So that's the thing. Right.
same thing happened on the last day.
Mr. Goyal,
The Lordship directed them to file. But then he said he is not well, so I would not like to object.
Right.
That's why, my lord. I will file, my lord. After filing, your lordship will
Very
see,
good.
my lord. Deeply obliged.
Deeply.
Sorry.
Item number 1.
You mentioned? Yes.
Item number 6, Your Lordship. Item number 6.
Number?
Item number 6.
Division bench. Which is a writ appeal.
May I please, Your Lordship? I'm appearing on behalf of the appellant.
Yes.
It will be after vacation, Your Lordship.
After vacation, asking.
Yes, Your Lordship, we have no objection as to that. It may be listed after vacation.
On a pre-emphasis so-and-so, listen, matter after vacation.
It's a wedge.
Supplementary list, item number 1.
What is this? I thought it was money for case.
Please, Lordship. Lordship, here we have come against the assessment order passed by the Superintendent of Texas, Meghalaya, my Lord.
Our case appearing for the state.
May I please, Your Lordship? I am appearing for the state. Only thing is that, Your Lordship, petitioner has challenged the show cause notice issued by this one. But there is the appeal provision to the commissioner.
To the?
To the commissioner of taxes. But petitioner has not availed that opportunity. Instead of exhausting that opportunity, straightway come to the High Court.
My Lord, we have come against the assessment order and subsequent demand notices, my Lord.
Why?
Apparently, this is a barred by limitation, my Lord. Because Section 56 provides that no...
Have you represented against these? Have you filed a reply against them?
Nothing.
Then?
And not only that...
My Lord, in my humble submission, my Lord, when it is apparently barred by time, my Lord, no assessment order could have been passed.
There is alternative opportunities there, my Lord. So...
Suppose it's brought to pardon me, I will take this
yes,
throat, for my throat. Yeah, the thing is that it looks like I'm eating, but I'm not. So, what I'm saying is this. Why don't you file? Are they aware of this discrepancy?
Nothing is filed.
Well, there is a statutory bar, my Lord.
You're not aware.
After 5 years, assessment order cannot be passed, my Lord. Here, the assessment period is 2000.
Okay, we'll do one thing.
Or they can file an objection, my Lord. They can file an affidavit raising all these objections.
Oh, let's put it off.
Yes, Your Lordship. There is nothing. Not only that, Your Lordship, I may be allowed to submit that there are...
Meanwhile, no course of action against you. You file a reply to them. And they'll take...
But the assessment order has already been passed, my Lord.
But
they issued a demand notice.
A show cause notice.
No, my Lord. Assessment order. My Lord, kindly come to page 13, my Lord.
No, where are you replying to show cause notice? Show that. Show the reply.
But there is no reply. My Lord, show cause notice has been issued to us now, my Lord. Why penalty should not be imposed? My Lord, kindly come to page 13, my Lord.
Page 37 is here.
13.
Page 13, my Lord. This is assessment order sheet for vatable goods. Assessment order has been passed, my Lord, imposing certain amount of tax on me.
Where's the show cause?
My Lord, after that, my Lord, page 12, the previous page, my Lord.
This on 9 August.
My Lord, this is why penalty should not be imposed on me, my Lord.
But
assessment order has already been passed. Tax has already been determined, my Lord, against me.
But Your Lordship, page number 37, show cause notice was there. Page number 37 of this.
This is also 8th August, my Lord.
But see, Your Lordship,
37.
87, page 37, Your Lordship.
8th August.
8th August.
And 8th August is the assessment order, my Lord. Page 13, Lordship will see.
No, contents of this notice is, Your Lordship, may kindly...
And you file reply better to clarify the facts. Heard Dr. Mozi Kalan at counsel for the petitioner assisted by so-and-so. Issue notice. MS S. Bhattacharjee appears for all the respondents. No further notice called for. Objections to be filed. She prays is allowed to file.
After vacation.
Objections after vacation stop. You want an interim relief?
My Lord, in the meantime, my Lord.
But Your Lordship, I have objection to this because I may be allowed to file reply because it is not a appeal provision.
Next date then, since you waited for so long. Yes, that, the next paragraph. We challenge instant repetitions against the impugned show cause notice and subsequent impugn show cause notice, or the challenge, sorry,
assessment order
in the writ petitions against the show cause dated 9/8/2023 and the assessment order and demand notice issued by the respondents. They have been submitted by Senior Counsel that the assessment and demand has been made in violation of the
Section 56,
Section 56 of the
Meghalaya value-added tax.
Meghalaya value-added tax regulation, and as such is unsustainable in law. Stop. He prays for that in the interim no course of action or recovery be made pursuant to the said demand notice. So, MS as per Shaji prays he will have to obtain instructions and to file objections to the pray for interim. Stop. Next, in consideration of the submissions made by the parties, stop. And in consideration of submissions made by the parties, let the interim, the prayer for interim stay be finally considered on the next date. Stop. On next date. In the meantime, no course of action be taken against the petitioners. File objection.
Your Lordship, one more submission, Your Lordship.
No more submission.
Item number 2.
Lordship, I am appearing for the respondent in this matter.
Yes.
Lord, it's fixed for admission hearing today, my Lord.
Yes.
If it could be taken up after vacation.
Why was the matter about?
This is service matter, BSF.
On the prayer of the parties, this is a matter of the vacations. Yes. For admission hearing.
Yes.
Daily list, item number 1.
May I please, my lord? I am for the respondent number 5, my lord. My lord, I have preferred SLP against the order passed in the MC 41, my lord. So this
is there a stay?
No, not yet, my lord. Honorable Supreme Court closes from 15th of this month, my lord. There was no sufficient time for us.
So what are we to do?
So it may be kindly different. It may be taken after vacation, my lord.
My lord, cannot be, my lord. Your lordship may kindly see they have filed a defective. I've taken out the printout this morning. It is cases under defectation valid for 90 days. So they can cure within 90 days. That means
it may be taken up just after the reopening of the Supreme Court's order.
My lord, may I just...
It will be finished before this
Your lordship,
vacation ends, my lord.
Your lordship may kindly see how they have been dealing this matter, the tactic. First of all, my lord, a division bench of the Imphal Manipur High Court, they stayed the order, my lord.
After 6
Thereafter, my lord, please, it was stayed, and thereafter they brought in, after...
May I make a submission, Lord?
1 second, Mr. Hari. Yes.
They brought in an advocate related to the leading judge. Thereafter,
no, my
there
lord,
was no bench. Please, there was no bench. Then why was it transferred by the Supreme Court? Then we went to Supreme Court. Supreme Court immediately, without even issuing notice, directed the transfer of this petition from Manipur to this High Court. Thereafter, they took time again and again, my lord. It has been observed by this Honorable Court, wherein it is observed that even the period lost will be restored on the first date. And then, my lord, one after another, they have been issuing orders, then filing affidavit, then file misapplication for closing the writ appeals. Then after dismissal, now they are saying that they have filed SLP. And my lord, this is how they want that we get frustrated. We have already come here for more than 10 times, my lord, so far. And their motive is very clear, my lord. They just want it to be delayed by any means, my lord. That is what they did at Imphal. And now they are doing it here, my lord.
Yes, Mr. Dari, what do you have to say?
Lordship, in fact, Lordship, the matter which is in consideration, Lordship, as though the Miss case has been dismissed, 41, Lordship, on the last occasion. Lordship, as SLP has been preferred, Lordship, any outcome in the SLP will directly affect the proceeding of this matter, Lordship. And in fact, the judgment was, this order was delivered only on 6th of December. And they have filed this application.
They have not filed it, my lord. Filed by the press number 5. He has not filed it. The state has not filed it.
Mr. Saume, can you allow?
No, you have not filed it.
This has been filed on 11th of December, Lordship, just less than 5 days after. Lordship, this matter may be taken after vacation. And Lordship, in fact, I have been served with a copy of a rejoinder by the petitioner yesterday only. by furnishing 2 additional documents and some pleadings running into
to avoid complications.
Pages. So some time may be given.
What rejoinder?
My lord, rejoinder in the contempt petition, my lord. The contempt petition, my lord, till they filed the affidavit, it was a civil contempt. After filing a contempt petition, it has become a criminal contempt because they have filed aspersions against this court, saying that this honourable court passed the order without hearing them. Please,
and then we may be given some permission. We may be given permission.
My lord, let me complete first, my lord. And then, my lord, they have filed that they cannot do this, that, and I have annexed the documents showing that they have done it.
But you have just furnished it yesterday, Mr. Sahu. You have just furnished it yesterday. So you will need to give some time to the government to go through.
This application is miscase number. It is an application for deferring of the hearing or present appeal pending consideration SLP file against order dated 6/12/2023, passed in MC bracket WA number 41 of 2023, arising out of appeal number 20/2023. Stop. That's all the counsel for the parties. Objections have been raised by Mr. BP Sahu, who praised that the matter be taken up for consideration today itself, in view of the fact that the matter has been taken up before the has been filed for Honorable Supreme Court. List this matter after vacation to avoid any outcome.
My lord, this cannot be a ground, my lord, because they are just, this is only for delaying, my lord. And my lord, your lordship may kindly see.
These are all tactics.
My lord, your lordship will kindly appreciate our difficulties, my lord.
We appreciate totally, Mr. Sahu.
My lord, for the last 10-11 times we have come before this honorable court, my lord. And, my lord, just on this, my lord, I'm very, my lord, this.
I understand your anxiety. All the same.
My lord, in that case, my lord, let it be on reopening on 29 or 30, my lord.
We'll have it, yes, first week of February. Yes.
Item number 4.
First week of January, February. My lord, let it be in the last 30 or 29, my lord.
You take the lead in court, Master, yes. We were ready to hear you.
Well, some observation may be made that on that day, whether Supreme Court takes up the case or not, it may be taken up.
It will be understood, because if no orders are there before that, the outcome.
No, my lord, delay time has been 90 days. Time has been granted by the Supreme Court for curing the defect, which they will never do.
There are so much we can do. Yes. Thank you.
Item number 4.
What happened to the negotiations?
Successful.
Successful?
Yes, ma'am.
We need instruction. In fact, copy. My friend is having some.
If I can place these letters, my lord.
Your Lordship may take this matter after vacation, my lord, because I have just received. And some legal issues may be pending in this matter, my lord. So far as payment is concerned, that is one aspect of the matter.
No, it's been resolved by your client.
So far as the payment is concerned, liquidation plan is there, my lord, of outstanding dues, my lord. But the larger legal issue that whether we are required to pay these damages for next 25 years, that would require.
Is a subject matter here?
Yes, Your Lordship. It's part of
Lordship, if I can just clarify on that point, Lordship may kindly look at the first letter which is in Lordship's hand. That is from the petitioner's side.
Yes.
So it contains the terms on which they propose to settle the matter.
Yes.
So the fourth paragraph, I believe, can be looked at.
Yes.
There is a figure mentioned, my lord, 565 crores.
Yes. 36 number equivalent.
36 number of installments. That 565 crore, my lord, includes everything. It's now all-inclusive, interest-free amount, my lord. Okay. It's specified there itself. So any damages, penalty, etc., it is all included in that 565 agreed amount, my lord. So this is the proposal from their side. If Lordship kindly turns the page, this is the acceptance from our side issued a few days later. Point 1 and the last point, point number 6 may be looked at, my lord.
Yes.
These are the two important points. They have agreed, they have undertaken to withdraw this case, my lord.
This is the... Your Lordship, let this matter come after vacation, my lord. I will take instruction.
Come tomorrow.
Your Lordship, no, it requires some legal issue is there, my lord. Because if I can explain, my lord, there is a power purchase agreement of 2017.
You're not going to go there.
What, your Lordship,
You're going by the letter that you send.
No, this is and in my letter I have said, my lord, payment. In their letter they said that all court cases relating to be withdrawn, my lord. Where is my consent, my lord?
Naturally, my lord.
That's why I want to take instruction and all.
My lord, we will
tomorrow,
not.
Tomorrow I'm having some difficulty, my lord. Tomorrow I'm having.
MS Colney is here.
Your Lordship, why the legal issue is important, my lord? Why I just explain what is the legal issue here. All these payments we are going to make, my lord. In 2007, we entered into a power purchase agreement. In terms of power purchase agreement with NTPC, my lord, we are required to buy the powers on predetermined margin. 78 megawatt was allotted to us, my lord. Now the tariff is so high that we are unable to buy it and sell it to the consumer, my lord. Ultimately, they asked for 18% LD, etc. We past dues from 2015 onwards, my lord. We have settled that aspect. And then we questioned the power purchase agreement before CERC, saying that under the CERC, this power purchase agreement is not valid. CERC, relying on tariff regulation, held that we are bound by tariff regulation, therefore power purchase agreement is valid. Now we have challenged both tariff regulation also and CERC judgment, my lord. So to that extent, tariff regulation is also in question, my lord, here. And payment is...
Tomorrow.
Your Lordship, tomorrow I will be having some difficulty. Your Lordship may have it on reopening immediately.
You can appear virtually.
No, there is some problem, some difficulty, my lord.
Lordship, with all due respect to my learned senior, it's a very simple situation. They were required to pay certain amounts to us. They have now agreed to pay certain amounts.
They've agreed. That's
we've reduced almost
any other without prejudice to your other claims or other.
There is nothing. So your Lordship, he can wait for at least reopening, my lord. If this fate of the case has to be over, that will be over. I will have discussion with the officials also that how they want to proceed. Because this letter has been handed over to me now by my friend only.
It's a very small discussion that is required, my lord.
Yes, since he's just got it just now. Yes, Mr. S. Jindal, Learned Counsel for the respondent, submits at the bar that the negotiations between the parties have been successful and has culminated in an understanding. The communication dated 17 November, which has been sent by the petitioner, and a reply to 28/11/2023 by the respondent has been produced for this court. Perusal of the two communications reflect that some understanding has been reached with regard to the payment of the outstanding amount and its liquidation thereof in 36 number of equal monthly installments. However, the Advocate General prays for some time to enable him to obtain specific instructions. As such, this is matter on reopening. A copy to communications dated 17 November 2023 and
28/11.
28. Here I kept on record. Yes.
Okay.
Item number 5.
May it please your Lordship. Lordship, this matter needs some more time, your Lordship.
What's this matter about?
This is they have challenged the repealing of the act, your Lordship.
What act?
Yes. The main act, your Lordship, has been
the university.
Lordship, yes.
Has been AG assisted by so and so. Pays for and allowed how much for that? 3 weeks for the time to file affidavit. Yes, thereafter also.
Apply, your Lordship.
We'll have single bench immediately.
Any mention?
May it please your Lordship.
Yes,
Lordship, I beg to mention item number 41 from the hearing list. I humbly pray that this matter be taken up after vacation, your Lordship.
After vacation is 41.
Highly your Lordship.
Yes, Vijay.
My Lord, I wanted to move tomorrow, my Lord, for listing a matter tomorrow, my Lord.
What matter?
Motion. It's a transfer order, my Lord.
It's a matter has been pending?
No, my Lord. It's we are filing it, my Lord. Today itself.
May it please your Lordship, I beg to mention item number 39, your Lordship.
Number?
39.
39 after vacation, yes.
Much obliged.
Where's the
Your
Mr.
Lordship,
Sheikh?
petitioner, Sir J. Sheikh.
Yes, that's it.
Your Lordship.
I think even these matters, these transfer matters, we'll take it after because it takes some time. Yes. It's also
After vacation,
After
right?
vacation.
After vacation.
Can we make? It'll come to my bench only. I think. Yes. Yes. These matters also as the. Just drop in after list these matters after vacation. That means item number 35 to
35 to 38, your Lordship.
to 38. Yes. Item 40. Ready with the matter.
Hello.
Obliged, Lordship.
40, I would like to request, let it come after vacation.
40.
I'm looking for Sinkan, he's not here, but I think his colleague is here.
He's ready, Mr. Khan. He's a petition. You have objection?
No objection, Your Lordship. No objection.
Yes or no?
No, Your Lordship.
Okay, after vacation then yes. Call the matter.
But I'm praying for an unlisted motion tomorrow, my Lord.
Regarding?
Regarding land acquisition, my Lord.
All unlisted allowed for tomorrow last day.
Item number 1.
Christmas bonus, yes, to the lawyers. Nowadays, very less filing. When we were juniors before Christmas holidays, that means it's a bumper harvest also. Yes. Yes, Mr. Shilla, what is this?
Lordship, this is a contempt petition, Lordship. The petitioner here is the Association of the Staff of the District Council, Lordship. We have filed a petition in the year 2020 for non-payment of salary, Lordship. And the Honorable
Where's the order?
High Court.
Page 9.
Yes, Your Lordship. Page 8, Lordship.
Yes.
Operative part is page 9, Lordship. Paragraph 5.
Now, quantum of shares 18% and 25% for this council.
Yes, Lordship.
It's 18% and 25%. Quantum of share is how much?
I have to take instruction, Lordship. That I think the District Council will be in a better position, Lordship.
Heard Mr. Jishila issue notice returnable in 3 weeks. Steps will be taken by the AD within 3 days. List on so and so.
Item number 2.
Lordship.
Yes.
Lordship, we have taken steps on respond number 6.
This is a motion. You've taken steps.
Your Lordship, I'm entering appearance on behalf of respondent number 6.
Very good. Mr. S. Dingdo today entered appearance on behalf of respondent number 6, so service complete. Where's the other respondent number 5? S. Rumthao. Here, movement 1 to 4. All sleeping. What's the matter about?
It's a land acquisition matter.
Land acquisition matter. 6 is whom?
Same of
Maharam, Your Lordship.
When will you file affidavits?
Your Lordship.
It's a matter for affidavit by respondents after vacation, yes.
Item number 3.
I'll call the S. Dingdo appearing for number 6.
Yes, Lordship. Lordship, this is for non-payment of the bill, Your Lordship. Well, the construction, I was given the construction.
Non-payment of bill?
Bill, for pending bill,
Is
because the
certified
completion
bill?
report is there already, Lordship. I've completed the work, but the bill has not been
Why
cleared.
not paying Mr. Sama's client's bill?
Just a 15%.
He completed the work. Why? What's the amount bill?
Amount of bill actually, as per the second instruction, it is about 90 lakhs something. 99 lakh 42,000.
Paid to you?
They have not paid.
Not 1 rupee been paid to you as yet.
They've already paid 85%.
85% is the 85% they paid. That is the previous. For there was 2 contractors. They have estimated the new cost
They
estimate.
never paid the whole bill. Is there any maintenance clause there?
They have
Anyway, issue notice.
Lordship.
Okay. Issue notice. Mr. E. Moomin present accept notice on behalf of all the respondents for
Lordship.
This after table for. Yeah, should we wait?
Item number 4.
Lordship.
Yes.
May I please, Your Lordship. Lordship, this is a transfer matter, my Lord. My routine transfer order was stopped by the state respondents twice, my Lord. I was posted at, my Lord, at the district agriculture
Who's
office.
respondent? Where's the government advocate?
Which case?
Item 4, sir. I was posted at a district agriculture officer, West Garo Hills, my Lord. Thereafter, my Lord, my routine transfer order was issued, my Lord, on 31st March 2023. There is 6 employees were transferred.
This was March 23, okay. What happened?
After that, selectively, my transfer order was stopped, being white order dated 3/4/2023, my Lord, whereby...
Why stopped?
My Lord, on the ground that some the private respondent was transferred also in my place, and I was sent to the subdivisional office at Dadangri, my Lord, on the ground that some project seed distribution and agriculture census were not completed. On the ground that the transfer was Captain Avians and estate, my Lord.
You completed that work.
After that, the work was done, and thereafter I filed a representation to the respondent number 2, my Lord, and the same was forwarded to the respondent number 2 by the deputy director, my Lord, deputy directors Garo Hills region, my Lord, that the work already been completed. Thereafter, my Lord, on 16 November 2023, the order was passed by the respondent number 2, whereby the Captain Avian's order dated was withdrawn with immediate effect, meaning thereby the routine transfer was in effect. And in pursuance to that, my Lord, the office of the district agriculture officer West Garo Hills Tura had issued a release order, my Lord, on 21st of November 2023. And as per the release order, I joined at the office of the Dadangri, my Lord, agriculture officer Dadangri, white joining letter dated 21st November 2023, my Lord. And immediately on the next day, my Lord, the impugn order was passed, whereby the order dated 16/11/2023 was cancelled.
So Dadangri or in Tura?
I don't know, my Lord. I have been released and I joined at...
Once he is released, my Lord, what remains now, my Lord? He only notice, we will file reply to the petition, my Lord.
My Lord, kindly see the impugn order, my Lord.
He has been released, my Lord.
That is what?
My Lord, I don't know the position exactly, because...
Tura for time being then.
My Lord, kindly see the impugn order at page 27, my Lord.
Yes.
May I read, my Lord? The withdrawal of the stay/aviance order issued...
You are too precious an officer, worker, that's why they all go fighting for you.
Only selectively my transfer order was stopped twice, my Lord, without having any reason, my Lord. Simply cancelled, my Lord.
But that is not...
under council petitioner, issue notice, Mr.
Respondent are there, my Lord. Private respondent is there.
The Advocate General is present on behalf of respondents number...
Mr. Sincon and Mr.
Sincon. He was not here, he's... And 125 to Mr. Sincon, present on behalf of 125. Conference called for, President takes step for issue of notice service. Issue notice to the one number 6 within 3 days. This thereafter for affidavit instructions.
My Lord. Hello, always.
Item number 5.
Yes.
Please, Your Lordship.
Yes.
Your Lordship, the petitioner in this case is aggrieved by the non-communicative action of the respondent authorities, Your Lordship, with regards to his representation dated 8/11/2023 in relation to the deed of declaration, Your Honor, Your Lordship.
Where is the representation?
Representation is at page 135, Your Lordship.
Yes. Okay, heard also issue notice returnable in 3 weeks. MS Island who has accepted notice on behalf of
1, 2, 3, and 4, Your Lordship.
2, 4. Stop a notice to issue 2, 5 and 6 by said post. Steps will be taken within 3 days. This after vacation days.
Obliged, Item 6.
May I please, Your Lordship? Lordship, in this matter, Lordship, this matter is with regard to the pensionary benefit, my Lord. My husband was died in the year 2001, my Lord. Thereafter, I filed representation. They have
2001, no family pension till now?
No, my Lord. Pensionary benefit along with the family pension. We filed representation. Thereafter, the respondents had issued letter to communicating us that to bring, there is a claim and counter claim, so that to bring succession certificate. The only grievance is now they have not, the respondents had not yet shown us any amount. What is the total amount lying in the office? So without knowing the amount, it's difficult to get the success. Yes,
now
my Lord.
2023.
My Lord, yes, my Lord. My Lord.
What are you doing all this time?
My Lord, we have filed representation, and then we have orally requested to the respondent, and the lady is not educated lady, Your Honor. That is the problem. She is from South Garo Hills. The only problem is, only difficulty is at present point of time, Your Lordship, with regard to the amount. What is the amount lying with the department, so that we can approach the district council for succession, and department may release the amount, my Lord.
I'll have it.
Ms. S.K. Hassan, issue notice, returnable in 3 weeks. Dr. M. Mozikal is with acceptance on behalf of all the respondents, no further notice called for. List accordingly, and so on, so. For instructions, affidavit. After 22 years, 23 years.
My Lord. Yes.
7.
Hello.
Please, Your Lordship, the petitioner herein, we are the member of a right Amwi in Jantia Hills. Now, we hold a belief that the goddess Muvi resides in the river called Thulumuvi River. Now, since time immemorial, we have been practicing our prayers in this particular river. Now, through development from the government, they have taken water supply from this river. Most of the department would come and approach us and inform us that they're going to have this kind of a project and would allow us to perform a prayer. So our usual prayer, which we used to perform
regularly or only once?
Yes, regularly. It depends annually or as and when it's required. So one of the project which the government by the PWD department, PHE department, has brought is this Jal Jeevan Mission scheme, where they are planning to take the water supply from this particular river, this Thulumuvi River. Now, when we came to know about this project, we approached the concerned department. We have requested them that we want to perform a prayer, which they have not allowed us. They said that we don't need a permission from you. We have got the DC office permission and also from the Ilaka, right?
But permission to do what? What permission?
Just to perform a prayer.
You want to perform a prayer?
Yes, we want to perform a prayer, and that our usual prayer should be allowed.
So after the prayer is finished, then you don't
we
go there anymore.
we don't want to obstruct. We understand that development is required, but you do not allow us to perform the
you don't
prayer.
claim ownership with the land?
No, not at all. Not at all.
You don't allow him to perform a prayers there. Why not?
That's right. But they've proceeded ahead with the project. So we have given a representation also.
So no, you only say that before the project commences, let us offer prayers once.
Yes, that's all.
Once only.
Once only. Once only, and also that's our prayer only in the red petition itself, that we may be allowed before the commencement of the project work, may be allowed to form a prayer, and also our usual prayer may not be obstructed or interfered. That's the only thing.
What's the usual prayer?
The annual prayer, and as and when it's required.
They obstructed. Where have you showed they obstructed you?
No, I have given a representation.
So where's the thing that you cannot do this anymore?
The objection was verbally. We have given a representation. Can you come to my representation, Your Lordship? It's at page 36. Goes all the way to page 44, please, Your Lordship. They have responded to one of the notice also, where they said that
objecting to the project.
No, not at all.
No, sure.
Yes, that is a prayer only. My prayer, first of all, was that to allow us, before the project commence, to allow us to perform a prayer, and our usual prayer, the customary prayer, may be allowed to perform that. Just two simple prayer, Lordship. Nothing with regard to the ownership. No. We have given a notice also, that is in the month of September and October, which they have not. They have given one letter that they said they'll look into it, and they referred that letter as to topmost priority, which they have not done anything till date. This letter by the concerned department was from the chief engineer of PHE. Can you come to page 45? That is a letter referring to our notice and representation. They haven't done anything. They've gone ahead with the project.
Well, the thing is, sorry. The thing is this. Now, they are preventing you from doing the prayers.
Yes.
In that particular place, are you? Are you obstructing the construction somewhere?
Not at all.
Then?
Not at all.
Then you want to make it inside a pump house or something? No.
No, it's just beside the river. That depends on the members and the Lingdo who will decide where exactly the prayers are supposed to perform.
See, it's very vague. No, it's not really any.
It's there, Lordship. Can you see their reply to my representation, the notice also? It's at page 45, which they have acknowledged the receipt of it, and they said they'll forward this matter to the concerned authority and they'll investigate into it, which they have not done. Because there's an apprehension that if the project proceeds ahead, there's a possibility that we may not be allowed to perform prayers. So that's again another apprehension.
You get instructions then?
It's very important that prayers are performed, because why
I understand, but then there's no, tangible.
There's also an apprehension for a misfortune in the right also if you don't do this.
Your Lordship, as direction has been made to investigate the matter, Your Lordship, I'll seek instructions.
Where's
this at page 45.
Your Lordship.
This is their letter.
Executive engineer has been directed.
Petitioner. Stop. The grievance of the petitioner, which has been brought before this court, is that the petitioners have not been allowed to offer their prayers at where?
Tlumui River.
At Tlumui River.
Which in Gentia Hills.
Sacred,
West Gentia Hills.
In view of the ongoing project of Jal Jeevan Mission. Stop. He prays that directions be issued. He submits that the petitioners and the residents have no objections to the development work or to installation of projects which is in public interest, but that the only prayers the only concern is that they may be allowed to offer prayers as has been done, as is the practice. Stop. Next, by MS said Inokuri has received notice on behalf of the
125, Your Lordship.
125 is looking to obtain instructions in the matter. This after vacations.
Your Lordship, there's a private respondent also here.
Respondent 6. No, first.
Your Lordship.
Bludgeon.
Your Lordship.
Bludgeon.
May I please, Your Lordship? Petitioners are the job card holders of village Aksikhandi, PS Fulbari, West Garo Hills, Your Lordship.
Which village?
Aksikandi.
Yes.
Yes. So, Your Lordship, my simple prayer before Your Lordship to direct the respondent number 3 and 4, Deputy Commissioner and Block Development to
Who
hold.
is praying for the state?
Election.
I am praying for the state, Your Lordship.
When the last elections held? When did the term get over last?
Your Lordship, last election was held in 17 and period was for 3 years, that is 20. Thereafter, no.
So what's happening now?
Now it is a.
Who's giving her a job card? Who's collecting the money?
Your Lordship, there is no provision in the National Rural Employment Guarantee Scheme that there is a caretaker village employment. But Block Development Officer has approved one caretaker annexure 4, page 19, Your Lordship, one caretaker village council, Your Lordship. So, Your Lordship, I am praying before Your Lordship to direct the respondent number 3 and 4 to conduct free and fair election. Because even Deputy Commissioner has also written to the Block Development Officer to conduct the election. Because 3 years village is running without any proper
instructions. Yes, just caretakers there, rightly or wrongly. But MS Chaji and Council Petitioner issue notice. Mr. So accept notice on behalf of the response number
124.
124. 124. No problem. It's called for. Just authentications for instructions. Affidavit.
9.
Do not matter. Hearing do not.
Your Lordship, in this case, Your Lordship, I have challenged the order dated 17 October 2023, page 131. Your Lordship, in this case, I am the headman of the Garudubi village, and as per I am the headman of the Garudubi village, and
of the
Garudubi village.
Garudubi.
Yes, Your Lordship. So here you say, as per Meghalaya seat food security rules, headman will be the chairman of the vigilance.
No other case pending regarding same village.
Yes.
There must be. I sound familiar.
Yes, Your Lordship.
This is the
similar prayer has been made in this, but a different writ petitioner has filed this. The first case which had come up recently is writ petition number 385 of 2023, which was filed on 30th November.
What order was passed there?
The order, Your Lordship, had asked us to take instructions whether the food grains are being distributed. So we got the instruction that food grains are being distributed, and October-November is an ongoing process, Your Lordship.
Why you filed again then?
So, Your Lordship, in this case,
and same order has been challenged.
It is not same, Your Lordship. But there, the villagers also given the representation against my removal, and here I came personally for my removal as a headman.
You didn't compulsory. First writ petition was through someone else.
This was for the food grain. This is not.
This is for what now?
This is for the removal of the petitioner temporarily as a chairman of the vigilance committee.
On what ground you removed?
No ground is given. This ground is given as because earlier I make the representation, and due to this I have been removed. And as per law, I will be the person who will be the chairman of the vigilance committee. As per Meghalaya Food Security.
You are Islam Haq Chaudhary?
Yes.
Temporary removes?
Yes.
Inquiry is over?
Inquiry
is not yet over, Your Lordship. And for the purpose of a free and fair trial, that is inquiry, he was removed because he was one of the complainants. Which is why, and in the meantime...
Then you complain against some Bahrul Islam, correct?
Correct.
As per his order. So they're holding inquiry, so it's suspended temporarily. Yes, so?
So, Your Lordship, as per rule...
What do you want?
So, I am as a headman, I am legally entitled to be chairman.
So you should be suspended. You can be suspended. That means, if you're headman, from this fair price.
As per this Meghalaya food security rules, there is no such provision. And as per provision of this Meghalaya food security rules, headman...
No, it said that because in exigency of situations, it said so-and-so, as president of the vigilance committee, you agree with being suspended as a president of vigilance committee, not headman.
Where is that? The same prayer is
I am not the claimant. I am not the complainant there. because I have forwarded the representative was given by the villager. I am not the complainant.
You are Islam Haq Chaudhary, correct?
Yes.
To read this order, the undersigned hereby temporarily removes Sri Islam Haq Chaudhary, Gobra Garudubi village as President of Village Committee, so as proceed inquiry matters smoothly since he is a complainant against the Barul Islam. You're not a complainant?
I am not the complainant.
He is the complainant.
I have just forwarded the representative of the villagers.
So the representation of villages at your instigation?
Yes, we received. The copy is given to me, and I have forwarded the copy.
Okay. Heard, Mr.
And may it please, Your Lordship, there are so many discrepancies in this writ petition regarding the dates, the annexures are not complete. So, Lordship, all that has to be also rectified, Your Lordship.
Heard, Mr. Ardent, you should notice, Mr. MST Yang and AAG, its president has accepted notice on behalf of all the
5 respondents.
It is pointed out firstly by her that a similar petition is already pending consideration before this court, being WPC 385/2023, and that the incident petitions but a duplication of the prayers made earlier. He has also drawn attention to the court to the she has also submitted that the petition is what?
It is only for the
removal defects, which had to be corrected. Stop. What do you want to do? List after applications. Defects, if any, to be corrected before that.
Item number 10.
Similar petition by B.Ed candidates challenging 18 months of DIUS.
But it's already been taken up.
Yes, matter is listed tomorrow. I have filed reply in that.
But this matter, he is having a delete. He is having a delete. The one delete is coming up tomorrow.
Now, why, if he has delete, why they're not in consideration?
My Lord, his name is shortlisted. His grievance is that, my Lord, in view of the Supreme Court order, shortlisting the 18 months in IOS delete is incorrect.
We'll have it tomorrow then.
Tomorrow, Your Lordship.
He will not be here, he said. The first items.
I have requested Bar Sulay to do it on my behalf. He will be there.
The matter, similar issues pending for this court listed together.
Yes.
And issue being the WC number?
Yes. Tomorrow we list.
Vicky and Sangma.
The PPC number 389, my Lord.
389?
Yes.
Also listed together.
Yes.
Tomorrow.
Yes.
Item 11.
For respondent number 5, I'm praying for some more time.
What to do? Let's pray for the 2 weeks time granted to the respondent number 5 to file affidavit.
12.
Your Lordship, I have received a affidavit, Your Lordship, so I'll file a rejoinder, Your Lordship, if required.
Yes, affidavit has been filed by the
respondent number 4.
Respondent number
4.
4. So, Mr. D. Henta, please pause allowed to extend by the agenda, if any.
All right.
13.
Please, Your Lordship. The Miss case we have filed, my Lord, they have given a show cause reply in the morning. We sought for vacating the modifying the interim order passed by my Lord on a few grounds. The only ground we are taking here, my Lord, the interim order was obtained, perhaps a wrong instruction from the party to my friend. The
wrong instruction?
My Lord, the submission advanced before the Supreme Court on the day of passing the interim order was that after dismissal of his...
My Lord, if I can just interrupt my senior, our reply is in the process of getting filed, my Lord. There were some defects in it. It's getting filed. It's not yet before my Lord, my Lord. We've given a copy, no doubt.
Come up tomorrow, my Lord, if Lordship permits.
Tomorrow is the last day. This is a matter after vacation. As objections are yet to come be on board. Objection by the petitioner by the appellant.
Appellant.
In the meantime, my Lord, may I pray in that case, since the LCT court also arrived, perhaps, let my friend also proceed preparing the paper book. That will expedite the hearing of the main case also.
First, let's see a miss case. Interim orders continue until further orders is.
Obliged.
14.
Because you are still delaying the matter, Mr. Changri, so changing counsel, this and that. Then.
Lordship, on the last occasion also I had made this submission that instead of wasting too much of Honourable Court's time on the interim issue, we can fix it for final hearing subject to what senior says.
Let the miss case is there. Let my friend prepare paper book.
That's his call.
Obliged.
Complied.
But here, my Lord, on last time, I placed the instructions, my Lord, because the daughter is claiming pension. She is to furnish one unmarried certificate, my Lord, or marriage certificate if she is married.
She's been harassed enough. It's a long case, a long pending case, I think. Get that one from Mizoram. She's got it, this and that. Correct?
Earlier, police verification was required.
Then?
If they can furnish that, I don't see any difficulty, my Lord, in that. Because entitlement is based on their marriage, my Lord. Daughters are only entitled if they are unmarried.
Who issues unmarried certificate?
Married, if she is married, she is to submit marriage certificate, my Lord.
Who issues unmarried certificate?
She has to give some evidence, my Lord, to that.
They don't just issue an authority that the people are unmarried.
Maybe self-certification, my Lord, or some affidavit. From the petitioner, my Lord. She is a daughter.
We have already submitted, Your Lordship.
She has to self-certify she's unmarried.
Because only unmarried daughters are entitled, my Lord, to pension.
Who will, he said, supply certificate is unmarried. Who will give a certificate, unmarried certificate? So unmarried girls should know also where to get the certificate from. Or men.
Maybe an affidavit, my Lord.
What affidavit?
That she is not married. There is no non-compliance as such, my Lord. Only some.
No, what is the format they have to give?
Well, the instruction.
There's declaration. There's declaration from self-declaration. Your instruction say the unmarried certificate.
Well, because the office has to verify. So for example, if there are 4 children, my Lord, how many are married, how many are not married? So only not married, they'll be entitled to it, my Lord.
Correct. But the issue. My voice is giving up. Yes.
Or, my Lord, the matter comes out of vacation. I'll try to facilitate, my Lord. Or whatever communication gap is there, we will try to bridge that.
See the order, para 3. Even whatever you ask for, she's provided. See at page para 2 first.
Well,
April's communication is 7/7/2023, where paragraph 5 is recorded, which is case of grant of family pension process to the pension immediately on receipt of verification from officer in charge Lunglei police station. That's been given to you now and still not paying the pension. You can't make so much red tape, you know.
My Lord, if the matter comes out of vacation,
Or you ask whoever
I'll intervene, my Lord.
appear in person.
I'll personally intervene, my Lord.
Yes.
We'll try to resolve
it. It appears that there's been a willful violation of the order of this court.
No,
despite undertakings being given earlier. Yes.
Not required. I'll intervene at my level, my Lord. I'll try to resolve it.
Dr. Musica prays you have some time to ensure compliance of the order as passed by this court. It is hoped that by next date order should have been fully complied with. Just after vacations also.
15.
I will make the person appear. These cases should be, in pension case should be an example. Yes.
My Lord.
Yes, you filed affidavit.
My Lord, kindly have a moment, page 26 of this applications, my Lord,
Yes.
of these petitions, my Lord. Paragraph 43, my Lord. Paragraph 43, this is the direction. In the final analysis, the respondent number 3, that is me, is directed to provide for payment of gratuity to the petitioners number 1 and number 4, respectively, after proper calculations of the same, my Lord. So what I want to emphasize here is, my Lord, of course, there is no time limit given on such and such period of time. We have to comply. And then now, my Lord, we have on our part sought for additional funds, my Lord, additional funds. And this is immediately after receive of the order. My Lord, my Lord.
Mr. P. Oben, submit he has received instruction and praise and notified affidavit.
My Lord.
Yes. After
Obliged.
16.
Rejoinder.
So,
Who for the respondent?
so you will be filing in the course of the day, Your Lordship.
You'll be filing the course of the day.
Yes,
Rejoinder.
Yes.
It's here before me.
Sorry, sir.
If party submits pleadings complete, it's a matter for hearing after vacation.
17.
Same, sir.
This, the petitioner is supposed to file the rejoinder, Your Lordship.
16, 17.
17, Your Lordship.
Corrected, yes. Same order.
18.
Yes, no settlement.
No, Your Lordship. No, Your Lordship.
They just misled you.
Yes, Your Lordship. As per the last order, Your Lordship, they were supposed to file the counter affidavit, Your Lordship. The respondent was supposed to file the counter affidavit on the 24th of November 23.
Yes.
Some more time. By next date, I'll file.
And Your Lordship, one small prayer, Your Lordship. In the meantime, Your Lordship, the other bills that are not connected with this particular matter shall be released to the petitioner, Your Lordship, because it's facing a lot of difficulties, Your Lordship. Although the letter was stated, Your Lordship, but the bills are not being released yet, Your Lordship.
But that is already there, the 14th September order, my Lord.
Yes, what do you want?
Your Lordship, the other bills that were pending.
That related to this, we can't pass orders like that.
Because of this particular, although the letter was stated, Your Lordship, but then the bills are not being released yet to the.
You file affidavit, you can't put him to so much,
I'll file
hardship.
by next date, I'll file.
Yes, though 3 weeks' time was granted on last occasion to file affidavit, Mr. Dr. M. Mozika to again praise some more time. In the interest of justice, for 3 weeks for the time allowed. It's expected next year the affidavit should be on board.
May please, Lordship. This petition actually was twice referred to the Lok Adalat for settlement. However, the officers on the 2 occasions they were not cooperating. But petitioner they have come on twice. On the last occasion also, it was on the 12th 2029. They didn't come.
Please, Your Lordship, in case number 19 and 20, both are connected matter. In 19 petitioner, I have not received any notice for Lok Adalat to appear. And in other case, the petitioner has received notice from the Lok Adalat. But in that event, Your Lordship, in second case, case number 20, they have cabinet, her deceased husband's name has been forwarded to the cabinet for regularization. So it is on record. But in item number 19, Your Lordship, I have filed affidavit in opposition, but my name has not been forwarded. So I may be given some time to inquire whether my name has been...
Your name, your government?
Government, yes.
Whose name?
My name is petitioner's name.
Petitioner's
name has been forwarded to the government or not. So sometime may be given, but in case number 19 I have filed reply already.
But 19 we have not received.
I have, your junior has
When reported that nothing could come out from Lok Adalat. So this is matters after application stuff. MSS submits that in 19. In WPC number 223 after it's been filed.
Yes, Your Lordship.
19 and 20.
Yes, let's together also.
Lordship.
Much obliged.
Much obliged, Lordship.
21.
May it please, Your Lordship. Lordship, the crux of the matter involved here in Your Lordship is the illegal removal and suspension of the petitioner number 2 as the headman. So, Your Lordship, the headman was removed on grounds of the impugn public announcement which was made by the respondent number 1, who is a necessary party here in Your Lordship.
Item number 21.
Yes, Your Lordship. The impugn public announcement, Your Lordship, is Annexure 7 of the main writ petition.
1 second. What miscase is this?
Miscase for stay operation of the impugn public announcement, Your Lordship.
You filed fresh?
Yes, Your Lordship. And along with, I have brought certain documents, Your Lordship, because...
What are you referring to now?
Annexure 7 at page
of the
37.
petition?
Yes, Your Lordship. Translated copies at page 38.
Annexure?
Annexure 7.
Page?
38, Your Lordship, is the translated copy. Lordship, the
You suspended since 23rd December 22.
Yes, Your Lordship.
How many stay the order now?
Your Lordship, we have preferred an appeal, Your Lordship, before the respondent number 3, the District Council.
What happened?
Your Lordship, the appeal was never heard. However, Your Lordship, may I draw Your Lordship attention to annexure number 17, Your Lordship, of the main petition.
Page? Page?
Is at page 80, Your Lordship. At first instance, Your Lordship, the respondent number 3, upon filing of the appeal, had stayed this impugn public notification. However, Your Lordship, later they may kindly refer to annexure 19, Your Lordship, which they have stayed the impugn public announcement. And to the contrary, Your Lordship, they have again withdrawn the stay application of the impugn public announcement.
This was dated 19 June.
Yes, Your Lordship.
Then?
And then, Your Lordship, the respondent number 3, to the contrary, they vacate and remove the stay order, Your Lordship, which is annexure 19, on 13 July 2023.
July 23.
Yes, Your Lordship.
What do you want now?
Your Lordship, I want suspension of the impugn notification. Your Lordship, at instant, presently, Your Lordship, I have received information when the filing for this miscase that the respondent number 2 now is disturbing and interference with the entire administration, Your Lordship. Lordship, may I draw your Lordship attention is that the petition number 2 is still holding the majority in accordance with the customary practices, Your Lordship, which is unanimous from amongst the villagers present in the Maungap village. Your Lordship, the impugn announcement which was made, Your Lordship, was made not in accordance with the statutory provision, which was...
You've been out of office 1 year, Mr. Lindo.
Yes, Your Lordship.
We heard finally, before you can pass the final order. We can't pass interim orders at this stage.
Your Lordship, but there has been so much interference before
Whatever it is, what to do?
Yes, Your Lordship.
I can understand.
Yes, Your Lordship. And Your Lordship, may I draw Your Lordship attention to Annexure 21 of the main application, Your Lordship.
Have you got a copy of this case?
Yes, I have received the
copy. Reply.
I'll file a reply.
And now, Your Lordship, presently, Your Lordship, why the entire matter, Your Lordship, there has been the respondent number 1 has been circumventing the actions of removal of suspension of the headman related to a land matter, Your Lordship. And this land matter, Your Lordship, is connected to the issue which will be listed tomorrow, Your Lordship, regarding compensation. Now, Your Lordship, in connection with this innocent application that I have filed, Lordship, and in the main application, my main grievances is on the grounds that it was a matter of suspension and removal of the headman, and during the course of the entire proceeding pendency of the appeal, Your Lordship, it has come up to a new issue and controversy, which is, Your Lordship, at Annexure 21, where from the post of the headman, which is the matter of controversy, Your Lordship, now it has been shifted to the issue which is related to a land, Your Lordship. And for the reason which I have approached before this...
is the land reason for removal or...?
Yes, Your Lordship. The land is a reason for removal because that land, Your Lordship...
That's correct, Mr. Nath.
Your Lordship...
There was appearing the other matter.
I'm appearing.
In the other matter also.
Your Lordship, the matter is listed tomorrow, Your Lordship.
For orders?
Yes, Your Lordship. The other case which is related to land compensation, Your Lordship, which has been filed by the respondent number 1. Your Lordship.
You filed it?
Yeah,
Yes.
I filed it.
This is a connected matter, Your Lordship, which by the respondent number 3 had issued this particular order, Your Lordship, for spot inquiry, Your Lordship, which is in respect to the land, while the entire issue and controversy, Your Lordship, prior which at first instance the petitioner, when they approached, was for the removal and suspension of the headman. And Your Lordship, circumventing every issue that has been involved, Your Lordship, has come to this entire issue related to our land, which the respondent number 1 claimed it to be a right land.
Sounds so complicated.
Yes, Your Lordship. If Your Lordship may fix this matter on the same date with the other...
Let's see.
Yeah. We'll file the reply.
But Your Lordship...
there are reply for the miscase.
There are so
Yes,
many
Lordship,
anomalies.
A miscase has been filed for...
Your Lordship, I humbly pray for suspension till opening of the court, Your Lordship, because at present...
Mr. Lindo Asi, without getting a reply, suppose we pass some order, it creates another situation where there's breaking of heads there.
No, Lordship, that has been occurred a lot, Lordship, which I have already enlightened in the application, Lordship, in my petition.
Since 23rd of, that's nearly 1 year ago.
Lordship, but the actions which, in accordance of the documents which I have relied, it's a continuous... Is a continuous...
File a short reply. We'll take up the other matter tomorrow. Meanwhile, miscase number 231. This application has been filed for stay of the removal order of the petitioner. Stop. No. Mr. Nath prays for us now to file a short reply to the same just after vacations. Yes. We can't now. You should have filed it earlier.
Obliged.
No time. I think other matters after at 2:15. Some matters are still left. Yes.
I'm sorry for interrupting, my lords. I missed out in the morning mentioning our... my lord, I pray, my lord, this is a matter which has been filed today, your lordships. Some urgency is there, if can be taken up tomorrow.
Lordship, I have a similar prayer, Lordship.
Why are you mentioning now?
Lordship, I missed it in the morning. It will process of filing. My
Sorry,
apologies, Lordship. I'll oblige, Lordship.
Where are the counsels?
Item 22.
Yes.
May it please your Lordship.
Yes.
We have filed the affidavit in opposition, Lordship, and we'll be filing in the course of the day. We've already served a copy, my Lord.
MS Njishillah, let us senior advocate, submit the affidavit for the just after vacation for rejoinder if any.
Much obliged, Lordship.
23.
Lord, I have filed this urgent early hearing application because this writ petition can be disposed of, my Lord. This matter, my Lord, there are two connected matters, my Lord, this item 23 and 24. Now, there are two vacant posts of Joint Director, my Lord, in the Urban Affairs Department. And both have made representations for consideration, my Lord. And one post became vacant in March 2022, and one in March 2023. Now we approach this Honorable Court, my Lord, for non-consideration for over almost 2 years, my Lord. Now they have filed a reply whereby they are saying that there is an issue of seniority between the two petitioners. That is the main issue which is delaying the entire process of holding the DPC for consideration, my Lord. My answer to that is, my Lord, my representation. It's a joint representation, my Lord. Kindly have my writ petition, page number 68, annex to 14.
Our petition, sir. Page number?
Lord, page 68, annex to 14.
Yes.
Yes, Lord. Lord, this representation is dated 14th of July 2023. This was made prior to filing of the writ petition. Your Lordships kindly have page 70, paragraph 16.
Yes.
If I may read, my Lord. That, Madam, in view of the situation, keeping in mind the objectives and goals of the department and the impetus being given to the GOI, we, the undersigned, are making this joint representation. So, joint representation by both the petitioners, my Lord, giving an undertaking that we both are willing to accept our respective seniority as may be determined by the department.
Yes.
And that if the department immediately considers a promotion at the earliest possible. So, my Lord, we are saying you decide. We won't quarrel over this.
Undertaking. You have not. It's not clear.
Lord,
Suppose you decide by yourself, say that petition number so and so will be considered senior so and so.
Lord,
for the same day.
My Lord, paragraph 22 again, my Lord, we state. Middle of the page, my Lord, this is a signature of by both of us, my Lord. The writ petitioners, BRM Lingdo and Ranjoy Soklet, my Lord. Again, my Lord, at paragraph 22, we say that, Madam, in the above context and at this juncture, though this representation, through this representation, we would like to place on record that two aforesaid officers would abide by whatever decision the government takes with regards to seniority. However, any further delay on the matter and subsequent promotion to the post of Joint Director, the planning cadre would be compelled to take recourse. So basically, we are saying, you please decide our seniority. Whatever decision we will abide.
What is the problem that she is saying regarding his seniority?
Well, the problem is this petition and this petition belongs to the planning cadre. Now the other petition, my Lord, and the other writ petition belongs to the engineering cadre, my Lord. And the eligibility for promotion is from both these cadres, including the architects. However, they are supposed to possess a higher qualification of postgraduate diploma in urban planning. So both do have the same. Sometime in 2014, the engineering branch petitioner, my Lord, he got himself transferred to the planning after he obtained a degree. So there it became some issue, my Lord. So, but as on today, we say that, my Lord, the department may decide on the seniority.
Where's an affidavit that is because seniority problem?
Yes, my Lord. The state's affidavit, my Lord.
Paragraph 9 and 10, Your Lordship. At page 3.
page 3 of the affidavit filed by the government.
Yes.
Para 9, my lord, 7 lines.
From the bottom. 1, 2, 3, 4, 5, 6, 7. From the bottom.
Not from the bottom.
From the bottom.
After 7 lines, my lord, your lordship was filed, a meeting was convened. Writ petition, a meeting was convened. If I may read, my lord.
No, but the thing is that fixation of your seniority would not have any, effect on other.
No, my lord, because we are
on the other.
no, my lord,
in the
because
cadre.
we are too senior most, my lord. So the issue is between this.
But now this Arsoklete has gone to planning cadre. His seniority is counted from there, and this who's this other fellow?
BM Lingdo.
BRM Lingdo. He's in the.
It really doesn't matter, my lord, because all the 3 cadres are eligible, provided they hold a postgraduate diploma degree in urban planning, my lord. Had he remained in the engineering cadre, he would have still been eligible, my lord.
Now the thing is that he should be retained, according to this minutes, should be retained in engineering branch, cadre not to retain seniority. I mean, in the engineering branch, who's senior? This BRM Lingdo or this Soklet?
At this level, my lord.
So just suppose.
Yes.
Just suppose for a moment that he's not in the planning cadre.
Yes.
Suppose he's in the engineering cadre. Who'd be senior?
My lord, in my personal understanding, at this level, with the post which they are holding, that is district urban planner, and also the assistant engineer, this writ petitioner and item 23 would be senior. But if the department decides that no, the overall service as such, so the other
overall service, see, this BRM was engineering cadre, right?
Correct.
Now
no, he's from urban.
In the engineering cadre.
Urban minute.
Engineering branch cadre, I mean, whatever they're saying here.
In the planners, my lord, planners.
Here too we can put general which fill up but 3 cadres, planners, architects, engineers.
Yes.
They come from 3 branches.
3 branches.
Right, so planner is this Soklet. Now.
No, Lingdo is a planner.
Oh, sorry.
And Soklet is from the engineering.
Okay, sorry, yes.
But subsequently, upon obtaining the higher degree, he was brought into the planners cadre, my lord. But otherwise, the equivalent post is, my lord, the DUP and the assistant engineer. Even at that level also, Mr. Lingdo is, this petitioner is, he had been promoted early in time. But irrespective of all that, my lord, we are saying you decide. You decide and please consider the promotion because Mr. Soklet is retiring, my lord, by next year. That is the whole problem, my lord. And we have and 1.5 years has already passed, my lord. Because in para 10 of the state's affidavit, they clearly say, my lord, that the answering deponent states that the issue relating to interstate seniority is yet to be settled, which has caused delay in the matter of promotion.
What do you say, Mr. Chulai?
Since the prayer has been made for considering the representation, Your Lordship, so I would have no objection, Your Lordship. The only thing is that
of essence, my lord. They should decide.
Then let them decide. Then
the only thing is that, Your Lordship,
but the thing is that some exercise be undertaken now, whether to keep the Soklet in the same cadre or shift him to the other cadre.
The only thing is that, Your Lordship,
he'll be senior, you said, to be Aram Lindo, correct?
Overall service.
That's what overall.
Yes. So it doesn't matter, my lord.
The only thing is that, Your Lordship, there, at paragraph 22, there is an undertaking that whatever decision taken by the government, they will be satisfied. Your Lordship will kindly record.
We'll record that, of course.
Lordship.
We have no objections to that, otherwise.
So far, disposal of this writ petition on the basis of the writ petition, I have no objection.
You file a miscase for what? For condition?
Not for early hearing.
Early hearing.
A miscase 234/2023 in WPC number 256. In both the cases you filed?
Yes,
yes, Your Lord.
separately.
I had to go in.
235 is the 234 and 235, my lord.
And this case number 235 in WPC number 257/2023. These two Mrs. applications have been filed by applicants therein seeking early hearing of the urgent early hearing of the respective writ petitions. And the type 234, miscase 234, 256, 256, and the second one will be same order, but will be 23, since two writ petition 235 in 257. This application has been filed for urgent hearing of the instant writ petition of the writ petition. On the ground that the delay on the part of the respondent deciding in settling the matter has resulted in deprival of the promotional benefits. The promotional benefits is stop. Heard Mr. P. Philemon Nongbri, considering the application and on the concurrence of the AAG's matters, the connected petitions taken up for final consideration and disposal. Same order, the next one. And the main petition 256. Stop. Mr. Philemon Nongbri and the Council of Petitioner submits that in this matter which concerns the prayer for constitution of, where's the prayer? Come in. For prayer for considering the promotion of the petitioner to the post of Joint Director, Urban Affairs. As per the affidavit of the state respondents, the only hindrance is the computation and reckoning of seniority between the petitioner herein and the petitioner in WPC number 257/2023. Stop. Learned Counsel has then drawn the attention of this court to the joint representation made by the petitioners in both the petitions, which is annexed at Annexure 14.
July 2023.
14, which is dated 14 July 2023. It is submitted that at para 16 and 22 thereof of said representation, these petitioners have given an undertaking that they are willing to accept the respective seniority positions as may be determined by the department if the department immediately considers their prayer for promotion at the earliest. Stop. He therefore submits that the hindrance as reflected in para 10 of affidavit will be overcome by the undertaking which has been given by the two petitioners in the consideration of their promotions. Stop. Next paragraph. Mr. Indishwar Island AAG submits that if this is the situation and the petitioners will not individually agitate for a seniority which will be fixed by the department, the promotion will be considered as expeditiously as possible. Stop. Having heard the counsel for the parties, and considering the materials present, especially the representation. Applicant community, firstly, the affidavit of the state respondents, para 10 whereof which is quoted in below.
Para 10 and 9 and 10, Your Lord.
Para 9 and 10 which are quoted here and below. As also the representation dated 14 July 2023, bracket next 14, of which paras 16 and 22 are quoted in below. The hindrance or difficulty in consideration of the inter se seniority of the two petitioners should not stand in the way of the state respondents considering the prayer as mere on the writ petitions. Stop. Accordingly, the writ petitions disposed of by directing the state respondents to consider the promotion based on undertaking as given in the representation dated 14 July 2023. Yes.
As expeditious.
Yes, the matter should be completed as expeditiously as possible.
Oblige, Your Lordship.
25.
Type of you 1, 2, 3.
What should we file the affidavit, my lord?
I pray that this matter may come up for hearing after the vacation.
Yes, parties submit that the plea is complete accordingly as a matter for hearing after vacations.
Much obliged,
You
lord.
won't file the joinder? Very good.
26.
Lordship, I pray for some more time, Lordship, to file my counter, Lordship.
Why?
Lordship, I could not file. I have received the...
What's the matter of pension?
No, this is regarding the not allowing the appointment order to join the petitioner in the service, Lordship, because there was a appointment order was given by the executive engineer. The SDO subdivision officer are not allowed to join in service. That.
What are you doing now? You're just hanging?
Now I am no more in the service also.
You're not, no more in service?
That means like master role. Actually, I was from master role. They have allowed me to promoted me to appoint as a peon. Lordship. There was an order also for the...
So what are you doing now? You're unemployed?
Now I am employed. Unemployed.
What's the instruction you received?
Lordship, in fact, he was a casual worker. Then his appointment was only for 89 days, Lordship.
Yes.
But as per the instruction, he did not come to join in the office, Lordship. Though he has annexed one joining report, that joining report, that appointment was made on 2nd of June 2023. But as per his joining report, it is stated that he has come to the office on 1st of June 2023, Lordship. How can he come to the office for joining prior to the date of the appointment order, Lordship? And in fact, he is a casual worker. And his appointment was only for a period of
typographical error.
89 days.
Even in the order sheet, it is order sheet is very clearly stated. This order was issued by the executive engineer, where it is stated that plus other allowances admissible under rules with was
I was asked allowed to join with before your appointment order you already joined the work.
It is not like that. Actually, they were given. It should be with.
This court wants to keep exchange the minimum. Have to conserve the voice. Anyway, what I'm saying is, did you join before your appointment order?
No, Your Lordship. After not actually. Actually, in join later. I have not mentioned any date also. But the order says that I should my appointment should be considered with effect from 1st June 2023. That so it is older very
so you
clear.
Join on 1st June.
Yes.
Before appointment orders number 2.
No, actually, after receiving the order, I just in the application, I just read
That's fair enough.
Yes.
He made a mistake. Because if said the appointment effective from 1st June
Lordship.
And his appointment 2nd June, he wrote 1st
Yes,
June.
yes. That is what, Lordship. Exactly.
I'll file small.
Let him file. Lordship.
I thought of disposing it off anyway. Mr. SC, please for allowed 2 weeks time to file affidavit Yes, thereafter.
Last Lordship.
27.
This is your Lordship. I'm praying for some time, your Lordship, to file the affidavit.
Respondent number 5, anyone appearing?
No, no, no.
Mr. M. Pala prays for allow him some more time? No.
No, Lordship.
You won't allow any more time?
No, Lordship. I think it's
Why?
more than 4 times, Lordship.
More than 4 times you've taken?
Yes, your Lordship.
Yes. What's the matter about?
It's about non-payment of the salary, Lordship.
See. Why not filing affidavit? I received instructions.
Yes, your Lordship, I have
Receive
received.
instructions. When do you receive them? One. You received it on 29 September.
Initially, it was taken up by my colleague, your Lordship. So it's not feeling well, that's why.
Who's Anil Lato?
My colleague, your Lordship.
You ever appeared in this court?
Yes, your Lordship, he appeared.
Only for 2 months you haven't been paid.
From 2023 March, she got the salary. After that, she haven't got the salary.
This is very sad. This officer already typed out affidavit for you also September. Look, Mr. Shulai, what is this? If see the affidavit is ready since September, why is not filed? Who was in charge of this case? It was absurd, really.
Lordship,
This is very bad. If tariff has been paid and no after been filed, we'll inflict heavy
Lordship,
cost.
kindly allow us some time, your Lordship. I'll go through, your Lordship. I'll take care of
You
the
have the right to object. Asking for time is a matter of course. Whether it's appointed or not, again, sanction post has suddenly released to the bank, whatever. Let the fact come before the court by affidavit.
Kindly allow us some time, your Lordship. By next year, your Lordship will file the affidavit.
Look at this. See, asking for time is a matter of course.
I'm sorry, your Lordship.
See, all annexures are here, everything.
By next year, your Lordship will be fine, affidavit.
When a prayer is made for, when a prayer has been made for extension of time for filing affidavit, the same was objected to by learned counsel for the petitioner. So, we learned GA and submits that instructions have been received, which were asked, which were submitted before the court. On pull of the instructions, it appears that the same had been received since the month of September 2023, but the affidavit unfortunately not been filed till date. The matter concerns claim for salary. It's expected that the affidavit should be on board before the next date.
Apply.
Take action. What is this? I mean, September's. It's 3 months.
28.
Yes. Otherwise, you'll have re-all your panel. Mr. RP General.
Lord, here I have received one instruction, my lord. My lord, here it says that the SDSEO, it appears to be, my lord, single teacher school.
Who is he?
My lord, the petitioner has a process for approval of appointment. Approval order, my lord.
What approval order?
For appointment. Well, the managing committee had forwarded a proposal, my lord, for approval.
What happened?
So, my lord, that was so far not approved. However, this letter says, my lord, that he has a mind to approve, my lord.
Having a mind and approving two different things.
That's exactly, my lord. So, if my lord grants me some more time, my lord.
As paid for the 2 weeks time granted to JGE for filing affidavit. Yes, that up. No objection. No?
29.
We object, I'll have to look at the instructions.
May I please, Your Lordship? Your Lordship, the petitioner was supposed to correct the cause title, Your Lordship.
Who is appearing for the petitioner?
Mr. Gurum, Your Lordship.
Mr.
R. Gurum, Your Lordship.
By order dated 4/12/2023, the corrections are allowed to be in the cause title by the petitioner have not been carried out. None appears for the petitioner list after 3. List is 2nd week of February.
30.
Mr. RK General, for to say, in the other matter that Sumoto called regarding the additional remuneration for Justice Kotaki will
yes, sir. Because Justice Kataki has not been paid for a long time, I think.
This is the transposition matter, my lord.
Yes.
The transposition, my lord. Respondent number 2 is petition number 2.
Anything more to be heard here?
Well, in my humble submission, if the transposition is allowed, the matter can be heard on merit, my lord. We are
now.
Well, not today, my lord, but tomorrow is the last working day. And in fact, the issue was very short, my lord. Interpretation of only 3 words, my lord.
Everything. I can argue on merit, my lord. It will take 5 minutes for me. 5 minutes only. I will show what my friend is saying, that debarment is not blacklisting. As consortium partner has been debarred by Uttar Pradesh Vidyut ne. Now, my friend is saying that our language used in our is blacklisting. So, debarment is not equivalent to blacklisting. Therefore, my undertaking did not talk about blacklisting. That is the case set up by my friend. Now, the notification or tender, NIT.
Cross the first hurdle.
NIT also says.
Which transposition is that's allowed?
That's not transposition. NIT says, my lord, that they will go by the procurement division orders of Government of India. Government of India notification says debarment is nothing but blacklisting, my lord. That is the
definition.
Definition. That is the definition. If I can, that's the end of the matter, my lord. And assuming, my lord, that this argument is not accepted.
If I may place my case, my lord.
Yes. This case for what, this one?
This case for transposition. This case number 215.
Okay. We pass orders in this case first. 215 is for?
For transposition, respondent number 2 is petition number 2.
Only one issue, my lord, in transposition is that authorization by Mr. C.S. Mani Yadav is to the company, my lord, to company to take up this step. That authorization in law is not correct. That has to be, my friend has to give correct authorization.
We have already placed the board resolution on.
Board resolution authorizing C.S. Mani Yadav to do it. C.S. Mani Yadav. But authorization says that it is authorizing Aparva. If your lordship will see page number 1.
Number 1 of?
Of the application. of transposition.
Yes.
Page 7. C.S. Mani Yadav, before the Honorable, do hereby authorize petitioner number 1 to represent an affixed signature. And petitioner number 1 is Aparva Energy Private Limited, my lord. That is a company, my lord. And one company cannot.
In 43, that authorized
one company cannot represent the other company. Only C.S. Mani Yadav could have filed the application, my lord, in terms of board resolution. That is the law. That is the problem which I see. That has to be corrected by.
These are very minor technical
But this is the law.
Who is the person who filed this application?
No, just have the affidavit and read the law. Read the law properly. This law which they're laying down in the affidavit itself is very clear that the company has to be represented by a natural person. That's what it means. Aprava is being represented by a natural person.
The thing is that he's authorized signatory of BCITS.
Yes. He's authorized signatory. He's authorizing the company, my lord.
Yes.
He can't authorize the company because by authorizing company means company is going to represent BCITS.
No, the company is again
one company cannot represent the other company. It is against Companies Act and against the law laid down by Supreme Court. C.S. Mani Yadav can file the petition. There is no, because board resolution they have placed before the court, my lord. So he can file it on behalf of BCITS to become respondent petition number 2. That is the error which he has to be corrected. Because now C.S. Mani Yadav is having board resolution in his favor, my lord, which was produced on the last date of hearing, 24/10. But C.S. Mani Yadav cannot authorize the other company to represent BCITS. That is the difficulty in the authorization.
Where's the board resolution?
Your Lordship, it was produced on the last date of hearing.
This is the judgment he's relying on. Okay, just read this. Just read this.
Where is that?
Your Lordship.
My lord, on the last date I have produced.
Yes.
That was taken on report, my lord.
Yes, on record, but can't find it here.
My lord, I have another copy, my lord.
If your Lordship will see, resolve further, second paragraph, that C.S. Mani Yadav, manager operation of company, is hereby authorized to further delegate such authorization to representative authorized by Aparva Energy. It's not to the Aparva Energy, my lord, representative, because law is very clear.
It's written wrongly, the thing, that's all. The wording is not correct.
Wording is not correct. That is wording.
I will overlook that.
Wording is not correct. That is what.
Transposition of this application have been filed for transposition of the applicant number 2, BCITS Private Limited, as a co-petitioner. That is petition number 2 in the instance petition. Stop. Next one, do initial objections have been raised? Have been raised as to the transpositioning of the applicant as petition number 2. Stop. This court, though not happy with the wording of letter authorization dated 26/10/2023, which is appended to the application. However, on the production of a certified true copy of a board resolution dated 24/10/2023, whereby one Mr. Shesh Mani Yadav, SHESH, Mani Rakajong, MNI, Yadav, manager, operations of company, being authorized to further delegate such authorization to representatives authorized by Aprava, APRAAVA, Energy Private Limited, deems the resolution to be sufficient for such transposition. Accordingly, the transposition application is allowed, and the applicant number 1, that is
number 2. Applicant number 2.
Applicant number 2.
Applicant number 2 is hereby read as petitioner number 2 after transpositioning in the cause title. That means the petitioner, that is number 2 BICTS. Okay. Please stands allowed. Yes.
Better short note which
But the present tender was issued, my lord. The relevant clause, my lord, the tender starts from page 56 onwards, my lord. This is NIT.
How long will it take?
It will take more than 15-20 minutes, my lord.
But court can't dictate the order, is a problem. Yes. Yes.
Now, my lord, page 56, your lordship will see.
Any urgency is a matter, Mr.
There is no urgency, my lord. There is no urgency, my lord. The order has already been passed, blacklisting them, my lord. That is a final order. So final order has been passed, my lord, and they are debarred and blacklisted, my lord. And it's a important project of government, my lord, to do the smart metering and to cut down the losses, my lord.
My lord, urgency is only to the extent, my lord, the interim protection that we have, my lord, is only that award of contract will be subject to outcome.
That is there, my lord. That is in any case indeed.
That
remain anyway.
That doesn't protect us, my lord. We are free to award the tender, my lord. So that is our only concern, my lord.
Because
whereas we, my lord, we submitted our tenders in terms of the NIT, my lord.
The date's already over now.
That is
over. The technical bids have been opened, my lord. We are qualified in the technical bid. Financial bids have been opened. Now in their affidavit, they have not disclosed, my lord, what is the outcome of the financial bids, my lord. But financial bids have been opened, my lord.
It's been opened?
It's open, my lord. They have placed the financial bid also, my lord. What we are going to do, my lord, instruction is that if the L2 is, we will negotiate with L2, that if he is going to match, or bidder is going to match the price of L1, then in that case we will award, or if the L2 is not going to match, then we will go for retendering.
So they are nowhere in the picture.
But they are blacklisted. They are blacklisted, my lord. They are blacklisted. My blacklisted. They are blacklisted.
My lord, after financial bids have been opened, my lord.
So wherever this blacklisting process has to be throughout the period. And they conceal this fact. Concealment is writ large. I will show that.
No concealment.
It's a concealment. What they are trying to say, debarment. I am debarred to undertake any project of smart metering. But that debarment for next 2 years doesn't mean blacklisting.
Blacklisting and debarment are two.
And Government of India Procurement Division has said debarment and blacklisting.
It's been debarred by MPTCL only.
By utility
of
Uttarakhand. That order is there, my lord. I will show from that.
So the utility will apply. That order will apply to.
That is our case, my lord.
It will apply to everybody.
NIT says if you are only blacklisted by some other state's utility, my lord, that will debar us. But here, debarment, my lord, I'll just point out the relevant clause, my lord.
If you are blacklisted, it will apply.
Yes, my lord.
If you are not blacklisted, it won't apply.
Is only debarment, my lord, it will not apply. That is their tender says, my lord.
My tender doesn't say so. That is the thing. His short issue is this only. And this is the interpretation given. Because, my lord, what is this? This is a smart meter project. The consortium partner has been debarred in the smart meter project because of various defaults.
BCIS.
BCIS.
My lord,
BCIS
has been defaulted.
And BCIS has challenged that order before Allahabad High Court or somewhere. They did not disclose that they did not get any relief, my lord. And they debarred, and I will show pages after pages that report so, my lord. Therefore, it's a clear-cut, unequivocal case.
Can you equate blacklisting to debarment?
Yes, kindly see two pages only. I will not see 2 pages only, my lord. Kindly see the 2 pages.
Wait 1 second. Let's hear what he has to say. Doesn't matter.
138, my lord. Kindly come to the tender document, my lord. 136. This is the format covering letter. Lead consortium and various partners are required to give, my lord. And kindly see 136, 1, my lord. One is basically, my lord, that they are complying with the all provisions. Then 2 is fulfillment of eligibility, my lord. And 138, 7, my lord.
Yes.
We confirm that we shall adhere to applicable laws for public procurement in India, including the guideline issued under order number Ministry of Finance, Department of Expenditure, Public Procurement Division, so and so, my lord. Kindly mark these 7 clause. And then kindly come to 14, my lord, at page 139.
Yes.
We confirm that we are not currently blacklisted by any government organization, regulatory agencies, government undertaking, my lord. Now they are saying, and then your lordship will see their undertaking.
Now come to 15 then.
And we confirm we are not currently banned, debarred by.
Now, why is issuing two clauses for that, debarred and blacklisted?
No, first is that we have not debarred in past. And
no.
Yes, sir.
We confirm we are not currently.
Has been
and
currently means
blacklisted by any government. And 15 we confirm we are not currently banned, debarred by the name of guilty or
because,
any
my lord,
issues.
there are 2 issues, my lord. When there is a debarment order, it is valid for 2 years.
No, fine. But you said the blacklisting and debarment equivalent is not. Why should you put 2 clauses?
And your lordship 15 also. 15 also. Kindly see 15 also. That's why your lordship I am obliged. We confirm that we are not currently banned, debarred by or any of the subsidiaries holding company. So we are not debarred and blacklisted both. Currently also and past also I am not debarred, my lord. And kindly see, and 7 I have read out, my lord. 7 I have read out. 7 is saying
currently not banned.
Currently also, because
there's no ban operating.
So suppose today I have given you the agreement, and then you are banned. Then that will apply. 15 will apply. When you submit the tender, 14 will apply. At that stage, my lord. So there are the various stages of the tender, my lord. And 7, your lordship.
Simple. We confirm you're not current. As on date, as on we're standing here, we're not banned.
As on date, I am not standing. And when you submit the bid and during the bid process evaluation, you are going to get banned.
Yes.
And then, my lord, kindly see, 7 is very important. That 7 it says that we will adhere to applicable laws and everything. And that laws has been, my lord, kindly see in my counter affidavit. That law is, my lord, at page 112. This is procurement, my counter affidavit, page 112. This is the Government of India, Department of Expenditure, Procurement Division. 7 clause 7, my lord.
Yes.
And kindly come to page 114, clause 4, my lord. The terms banning of firms, suspension, blacklisting, etc. convey the same meaning as debarment.
Where is it?
I am reading 114, my lord.
114.
1 and clause 4, my lord. The terms banning of firms, suspension, blacklisting, etc. convey the same meaning as debarment, my lord. 7 says that we will adhere by all laws, my lord. Now, I ignore this definition also for sake of argument, my lord. Kindly see the order of debarment, my lord. At page 597, my lord. And they have challenged this order before the High Court, my lord. They last time orally disclosed. Kindly see the order.
What happened to the challenge?
Challenge is they have not disclosed anything, my lord.
Still pending.
And there is no stay, nothing, my lord. And how can I trust them, my lord, when their conduct is so bad?
My lord, Learned AG has not referred to in the bracket words, my lord, name of the utility, my lord. I'll come to that, my lord. Name of the utility.
588, my lord. Kindly see the discussion. From the above, it is evident that data provided by billing agency in connection with low billing cannot be accepted. Para 2 of the so-called. I'm sorry, my lord. 588. From the above analysis, it is evident that data provided by the billing agency in connection with low billing cannot be accepted. Para 2, my lord. B. allegation of low progress in probe billing is levelled against the billing agency. Billing agency has informed that in agreement of connections are stated to be downloadable in billing area and DISCOM, where DISCOM has calculated percentage of probe billing against total metered amount so and so. It is further stated that billing agency that meter of 58 types are installed in the area, out of which are not compatible for meter downloading will, which is more than 70% of total downloadable meters, my lord. It is also stated by the billing agency in reply that even after providing probe of various types of meter readers, number of probe billing could not be increased because of seal in dirty port, particle port, installation of meter, outdated meter, etc. And single, according to RIP, all these matters, my lord, have been the 100 pages, and they kindly see the conclusion, my lord. Each and every aspect has been considered, and 597, my lord. From the analysis of the report, evidence and data produced by the firm at the time of hearing in reply to source cause notice issued by PUVVNL and in compliance with direction of the Honorable High Court, it is evident that joint venture of Messrs. BCITS Bangalore and Messrs. Contempt did not ensure compliance of sub-clauses or agreement, due to which billing target could not be achieved, and negligent working style and practice of the firm has dented the image of department in common public and consumers. Also, it is evident that despite instruction of metering amending their working system given to the firm by various letters of DISCOM and distribution areas during the working period, joint venture Messrs. BCITS and Contempt did not reflect any improvement in their work as expected in the sub-clauses of the agreement. Though financial punitive action was taken under the provisions of the agreement as per direction of UP Power Corporation, but from above facts analysis, it is evident that requisite improvement did not reflect in the working culture of the firm. And keeping this fact that in view and to save the corporation from fiscal and financial loss, in future, Messrs. BCITS and so is debarred from participating in all tender work of PUVNL Varanasi for a period of 2 years from the date of issue of this office memo interest of the corporation.
Yes, I want to show one thing now, that debarment applies also to the utility that your company.
Yes, your lordship, kindly see the page 138, my lord, the 138 where the undertaking is there. 138, my lord.
They are at petition.
No, this is the undertaking which they have given, my lord.
The affidavit.
130 intended document, my lord. Debarment is up.
Page 138.
139, 138, 137, your lordship, 138, your lordship, clause 7 has seen earlier, my lord.
138, yes.
We confirm that we shall adhere, 7, my lord, to applicable laws for public procurement in India, my lord. I have shown the definitions of public procurement in India, my lord. Then 14, my lord. We confirm that we are not currently blacklisted by any government organizations, regulatory, government agencies, government undertaking, my lord. Debarment, and they are saying debarment is not blacklisting, because you have used the word debarment. The PUVNL has used the word debarment. We have been debarred for 2 years. Debarment is not equivalent to blacklisting.
Now, Mr. Mazgai, 15 says that we are not currently banned, debarred by any utility. Is any utility?
No, my lord.
Yes.
Clause 15 says, my lord, we confirm that we are not currently banned, debarred by the name of the utility, my lord. My lord, here, my lord, I'll take your lordship to the another clause, my lord, how utility is defined, my lord.
Utility is defined in Electricity Act.
I'll just come. My lord, page 86, your lordship kindly comes.
How the repetition?
Repetition.
Yes.
Page 86, clause 00, my lord. Utility is defined, my lord. Yes. Means the entity named and briefly described in the bid data sheet that is issued in the request for bids for appointment of so and so, so and so. Now, bid data sheet, my lord, your lordship will find at page 110, my lord, 110.
$110.
110.
Yes.
110 is the bid data sheet, my lord, on the top. And 2.2.2, name Mr. So-and-so, Meghalaya Power Distribution Corporation Limited, Lumjingshai, Shillong. So, utility for the purpose of clause 2.2.2, my lord.
Yes.
So, my lord, the word utility for the purpose of this NIT, my lord, will mean Meghalaya Power Distribution Corporation or its subsidiaries or its holding company, my lord, in terms of clause 15. It cannot mean any other utility situated outside the state, my lord.
My lord, I know who is debarred.
Where does it say that it's a utility?
My lord, clause 15, my lord, your lordship has seen.
Yes.
We confirm that we are not currently banned, debarred by the, in the bracket, name of the utility, my lord.
Or government organization.
Yes.
Name of the utility, my lord. Now, what they are required to do, they are required to fill this up by MEPDCL, my lord, because utility is defined, my lord, here. As I've shown, my lord, page 86 says what is utility for the purpose of this NIT, my lord. Page 86, clause 00, my lord.
No, what I'm saying is now I'm just court can't understand. You see, this we confirm we're not currently banned, debarred by the, that means it'll be MBCCL only.
My lord, that is the crux of the matter, my lord. My lord, clause 15, the previous clause will apply to clause 14, my lord, that will apply to blacklisting by any government organization. If you are blacklisted by Uttaranchal, my lord, then we had no case, my lord.
They have been blacklisted.
But we are simply debarred by Uttaranchal, my lord, and debarment by Uttaranchal will not debar us, my lord, in terms of the wording of clause 15, my lord.
Fine line. Wait, next, where's deficient utility? Let's see.
My lord. Page 86, my lord, in the tender document itself. Utility means the entity named and as briefly described in the bid data sheet that has issued the request for bid for appointment of advanced metering infrastructure, so and so, on design build, so and so. Now, I've indicated, my lord, what is the bid data sheet at page 110, my lord. Page 110, my lord. Mr. M.B. Kurba, there must be some officer of that, Meghalaya Power Distribution Corporation Limited. It doesn't say any utility, my lord. It says name of the utility, my lord. My lord is in clause 15, my lord.
Yeah.
If the words were any utility, my lord, maybe the learned advocate was right, my lord.
No, does it mean that this utility means MPTCL? That's all.
Yes, my lord.
Not near utility, any, or it means any utility that debarred you.
My lord, utility as defined, my lord, it says utility means the entity named as briefly described in the bid data sheet who has issued the NIT, my lord. Now, who has issued the NIT, my lord? MEPDCL has issued the NIT, my lord.
Yes.
And then it says, my lord, or, okay, clause 15, I'm again reading, my lord, name of the utility or any of its subsidiaries or holding company. The holding company will be MECL, my lord, Meghalaya Energy Corporation, and other subsidiary company can be Meghalaya Power Transmission or Power Distribution, my lord, or Power Generation, my lord. If you are debarred by any of them, my lord,
yes,
you would have been covered by this, my lord.
Yes, Mr. Arvijan.
Yes, my lord. Now, my lord, what my friend is saying...
Debarment and debarment...
No, my lord, in that regard, my lord...
Debarment is not equivalent to blacklisting.
My lord,
that is what my friend is arguing.
My lord, I'll place one decision, my lord. How debarment and blacklisting are different, my lord.
Once my friend is finished, then I will ask.
My lord, I take my words in before my seniors. One documents which we felt it is very important to bring it before, my lord. Because now the talk is about the BCITs, whether debarment or blacklisting, and then now, my lord, I represent BCITs, my lord.
Yes.
Now there's a notification by the Uttar Pradesh Power Corporation Limited, which is a parent. The parent, which is a parent organization of the Purvanchal, which has debarred me, my lord. Now, very clearly, my lord, their notifications distinguishes what is a debarment and what is a blacklisting, my lord. My lord, may this will assist us, all of us, my lord.
Where is that? Which clause?
My Lord, my Lord, this talks about circumstances and procedure for banning business with forms / blacklisting forms relocated debarring blacklisting order, my Lord. So this, under what circumstances blacklisting will happen, under what circumstances debarring will happen, clearly distinguish. Therefore, my Lord, what my learned Advocate General said, debarment is nothing but blacklisting, my Lord, which is not correct as per this notification also, my Lord. This is what I wanted to emphasize, my Lord. The rest, we are supporting the principal petitioner, the Aprava, my Lord.
Okay.
My Lord, the decision of Delhi High Court, my Lord, I placed in last document.
Sani Kirkwood.
Yes, ma'am. I'm referring to para 19 only, my Lord, of this. Very succinctly, the Delhi High Court has defined what is debarment and what is blacklisting, my Lord. And what is the fine distinction between that? Para 19.
Yes.
There is a difference between the order of banning and the order of blacklisting. While, as in the case of banning order, there would be a period which would invariably be specified during which the party person would suffer a disability or disqualification of conducting the business with the organization passing the order. In the case of blacklisting, the organization which has passed the order of blacklisting prevents the party or the person from conducting the business for all time to come to with it. It is totally untenable in law on part of the petitioner to urge that the impugned order is an order of blacklisting because it prevents the petitioner from conducting the business only for a period of specified therein. And my Lord, this is reflected in the NIT itself, my Lord. Clause 14 and 15.
Totally different.
If they understood it as in the same manner, my Lord,
So
there was no need. There was no need to have a clause 14 separately and clause 15 separately, my Lord.
Yes.
It's 71. Just to add, it's 71. It's 71. It says.
Yes.
But the same view is there in the bid document also, only page 71, if lots of candidates, my Lord.
Yes.
My Lord, page 71, the third para, my Lord, the bidder participate in a bid.
Yes.
Well, the first clause deals with blacklisting, second one deals with debarment, my Lord. The bidder participating in a bid as a sole bidder or as a consortium member or as a lead consortium member of a bidding consortium and its subcontractors should not be blacklisted by any government organization or regulatory agencies or government undertaking as on the date of submission of the bid. Bidder should submit a self-undertaking signed by its authorized signatory for the same as per the format prescribed it. Form 7. The second one talks about debarment, my Lord. So, my Lord, the NIT terms read with page 138, 139, my Lord, clauses 14 and 15.
Yes.
Now, the respondents cannot say that there is no distinction between blacklisting and debarment, my Lord. Their very intention is that they are using these two expressions in two different senses, my Lord.
Interchangeable.
Now they can say these are interchangeable, my Lord.
Yes, Mr.
Yes, my Lord. Yes, my Lord. First argument.
That point.
My Lord.
That's the only point.
That is the only point for consideration, Your Lordship. Moreover, my Lord, my learned AG was referring to some central government. These are the NIT issued by Meghalaya Power Distribution. They are bound by their own terms and conditions of the tender, my Lord.
Lord.
Subject to what learned AG.
Now, first argument is, my Lord, that the at page 138, there are two expressions used, debarment and blacklisting. Your Lordship, kindly see 138 for a moment, my Lord. But before I take your Lordship to the relevant clause 14 and 15, I first meet the argument with regard to applicability of central government interpretation of debarment and blacklisting, my Lord. Because what my friend is saying that central government directions, orders will not apply to NIT, my Lord. That is the last argument which has been advanced, my Lord. Kindly see page 138, paragraph 7. First argument is that, my Lord, we confirm that we shall adhere to applicable laws for public procurement in India, including guidelines issued by Ministry of Finance, Department of Expenditure, Government of India, my Lord. Same Ministry of Finance, Department of Procurement, my Lord, as definition has given, debarment is equivalent to blacklisting, my Lord. And this is incorporated in the tender, my Lord. This is built in. This is, my Lord, this is built in the tender document by the parties, because whatever is followed by Government of India, we will follow, my Lord. And same procurement division, my Lord.
No, well and good, fine.
So then, my Lord, so if
they'll follow, but the things are the fine line between.
No, so now the question is
that,
now if
blacklisting and
I'm coming to that. I'm coming to that, my Lord.
Yes.
What your Lordship is falling from your Lordship is blacklisting and debarment. There is a fine distinction. Yeah. That is the issue which is troubling us in this moment. Now, debarment, they say that I am debarred for 2 years. Is it for definite period? It would not amount to blacklisting because two different expressions have been used, my Lord. For that purpose, but what I was trying to canvass before your Lordship is that the definition of debarment and blacklisting for this tender is concerned, it has to go by the Government of India's notification, because we, the parties, have incorporated clause 7. Right. That is my argument. That is my argument, my Lord. That is my argument. Because if the clause would not have been incorporated, this is my argument that clause, the Government of India definition, Government of India's definition of debarment and blacklisting is one. So that has to be equated, my Lord. And that cannot be distinguished in this tender, terms and conditions of the tender. Now kindly come to paragraph the page 139-14. This is my first argument, my Lord. We confirm 13, my Lord, I will read slowly, that no order, ruling has been passed by the competent authority or appropriate commission against us or any of the consortium members or proceedings for breach of any contract that the bid security submitted and has been forfeited either wholly or in last 1 year from submission of the deadline. 13, your Lordship has seen. Yeah. Now 14, because they are saying no order. Order I have shown, my Lord, PUVVNL order. 14, my Lord, we confirm that we are not currently blacklisted by any government organizations, regulatory agencies, government undertaking. So what is being argued and submitted before your Lordship is that I am not blacklisted, but my petition number 2 is debarred. So 14 will not apply. That is the plain and simple argument of my friend. My submission is that once blacklisting has been equated with the debarment, you can't put it into different place. Now they are trying to read 15 saying that you have got two categories, one blacklisting and the other is banned categories. So we are not currently banned, debarred by any of the subsidiaries, holding company, utility. Now there what saying that in 15 banned is used, not blacklisting is. Because, my Lord, if 13, if I am blacklisted in 14 and my blacklisting or debarment has taken place after submission of the bid or at the time of declaration, because if your Lordship will see, this debarment should be continuous one. It's not that it is at the time of bid I am not blacklisted and subsequently I am blacklisted, I am not out. You have to maintain this position throughout the period. It's not that you can't maintain this position. So this, in my humble submission, has to be read in that context only. Now kindly see 139 again 15, my Lord. Yes. We are not currently banned, debarred or any of the subsidiaries in holding company. What my utility, they have given the definition of name of utility. Now name of the utility is, my Lord, or any of subsidiaries holding company. What they say that definition of utility has to come from the tender document. And therefore if I am not debarred by MECL, I am eligible, my lord. Kindly see the definition of utility, statutory definition of utility given in the Electricity Act. This is the statutory definition given in the Electricity Act, my lord, which I have quoted in my counter affidavit also, my lord. 275. Utility means, sorry,
yes, 275.
Section 2, subsection 75, my lord.
2?
Section 2, definition section, and subsection 75 of 2, my lord. Utility means,
yes,
the electric lines or electric plant, and includes all lands, building, works and material attached thereto belonging to any person acting as generating company or licensing under the provisions of the Act. PUVVNL is the licensee under the Act, my lord, and it is an utility. Now what my friend is asking to take a narrower view of the tender condition.
No, this utility is not the same definition is in the.
Your lordship.
This is definition for the purpose of the Electricity Act, my lord.
Now I'm coming. I'm trying to answer.
It's not a tender.
No, my lord.
It's not a tender
In tender, I use the word utility. What they say, utility. If you are blacklisted by the utility, if he is blacklisted,
utility means that company.
Utility means the generating company or licensing company, my lord. The PUVVNL is a generating or licensing company or not? It is a licensing company, my lord. It is a utility under the Act. My friend is saying that under the tender, you have to read the definition of utility which is given. You don't go by the utility, because if I am banned by any other organization, that ban will not apply because I am not banned by you. That is the narrower view which my friend is trying to canvass before. And that is the
fine. I have been banned, but another utility has no connection.
So what my friend is saying that if I am banned in all utility in India, that ban will have no effect so far as banning, because your tender terms and conditions. Now, in my humble submission, there are two possible interpretations, my lord. If one advance canvassed by me and one by, and the tender authority has taken a view. Whether that view in my humble submission can be replaced in judicial review, that I have got some certain judgments, my lord, compilation on that point. But I will come to the compilation later on. First I have to, whether this would amount to arbitrariness. My friend is saying, I take it in law. This would amount, and your lordship has, but before I go to that aspect, my lord, I just quickly deal with this judgment, my lord, debarment and this. This is a judgment before the Constitution Bench Urja judgment came, my lord, 2008 judgment, where the Supreme Court said that you can't debar the companies for, or blacklist the company for indefinite period. And here, therefore, in that context, in paragraph 19, the distinction has been made. Blacklisting means debarment for indefinite period. So that 19 is not a good law, my lord. Kindly see paragraph 19. This law is no longer good law. There is a difference between the order of banning and order of blacklisting.
What's the latest law?
As a law is, my lord, blacklisting has to be for definite period. You can't take away the fundamental right, yes, and that is why security, this Gorkha security is the judgment, my lord, on that. I will place that also. While as the case of banning order, there would be period which would be verily spared, while the blacklisting there will be indefinite. This is no longer good law, my lord. Blacklisting, now the Supreme Court says you have to give the definite time period. So therefore, this judgment is neither, in my humble submission, neither here nor there. Now kindly see the judgment. On this issue, my lord. And my lord, relevant paragraph of the judgments, my lord, I have produced, my lord, in my counter affidavit, my lord, because time is short, my lord. Kindly see those counter affidavit.
5 minutes, you'll finish the case.
2 minutes.
That's why we started getting this matter. Otherwise you won't.
I know, your lordship is not feeling well. I can see that. My lord, kindly leave that part, my lord. Kindly, I have quoted those judgments in my paragraph only for the sake of reference, my lord. I have given complete judgment. And if your lordship will see my counter affidavit, paragraph 9, my lord.
That's the thing. 5 minutes stretches.
2 minutes, my lord. I will not bother, my lord. Kindly see page 9, my lord. Of my counter affidavit, I will just show 1 or 2 judgments from here only. Relevant paragraphs are highlighted, my lord. Your lordship take note of my paragraphs only. That is all I have to submit, my lord. Paragraph: the learned single judge and the division bench of the High Court were exercising the power of judicial review to find out whether decision of the state was manifestly arbitrary or unjust, let down by this so and so. Now, these are the parameters, my lord, which are there in my counter affidavit, my lord. I need not read all these things. Your lordship has also applied in recent judgment also of your lordship. That judgment in tender matter was there, my lord.
Which one?
That judgment your lordship has applied, and probably I have cited also, my lord. Is there, my lord, at page 70. That judgment of your lordship I am relying upon. So all these judgments, my lord, say that if the view taken by the authorities is a probable view, my lord, then this court may not like
only
to.
Only one thing is that the tender committee itself has rejected the bid, correct?
Yes.
You have not gone there. Tender committee has rejected the bid.
They selected us first.
They
selected, they qualified us, they opened our financial bid also.
Who disqualified you?
Much later, my lord, after we submitted our...
When we came to know complaint is there, we complained, how do I know? They don't disclose it. Binding order, the High Court order, they do not disclose anything.
My lord, kindly
this is a concealment also, my lord.
My lord, kindly turn
what
to
do I
page
do?
502, my lord.
I can show, my lord, from their own reply, my lord. Kindly see. I received the complaint.
It's not so simple as it seems.
They have concealed this fact.
Very easy to say simple, but it's not simple at all, because it's a very fine line and needs a lot of discussion with regard to whether the debarment, in the surface looks very simple, but debarment, whether what would be the exact, implications of debarment by one utility, and that also reflects on the suitability of the petitioner also, correct? So whether, but taking a considered decision, they can import that public utility will mean any utility or what. That's because the tender condition is quite vague also.
My lord,
that's only one.
If lordship kindly sees page 502, my lord, that will clarify to some extent. What undertaking in terms of that clause 14, 15 we have given, my lord. They accepted that, my lord.
How do I know? You did not disclose. I came to know later on. Complaint is there. You give false affidavit, false undertaking. This undertaking has got no meaning.
At least let me please complete, then you can have your way. No problem.
I'm directed against your client, not you against you.
Yes, you're not currently banned debarred by the...
Yes, your lordship kindly see.
By MEPDCL or any of its subsidiaries holding company.
Before that also,
once you write that we are debarred by so-and-so.
And before
they are not asking, my lord, they have not asked us to write that, my lord. My lord, they have not asked us to write that, my lord.
Just same, my lord, page 502 only, second paragraph of this. Be confirm that we are not currently blacklisted by any government organization, regulatory agency or government undertaking.
Yes.
And procurement division, the definition, which they say that it is binding on us, it says that debarment is equivalent to blacklisting. That is the interpretation which we have accepted.
My lord, I'll take your lordship through the notification which learned AG is cited, and to which he is referring, my lord.
I think we can generate a judgment right now.
And this is a possible view, my lord, because I can't deal with a company which has got such a bad reputation. It is a public interest which is larger public interest, private interest versus public interest.
We have to give full-fledged hearing. This one. We can't hear it because this deserves a proper.
Our only concern, my lord.
Because they have to make out the case.
They should not render it infectious, my lord. We are L1 bidder, my lord. Kindly note that, my lord.
Any tender
the public
awarded,
interest requires, my lord.
Any tender awarded will be subject to outcome, and your lordship will set aside if he succeeds.
Can I just?
But that is
public interest
no
also requires that a work is awarded to L1 bidder, my lord. On some technical grounds, my lord, which is does not find place in the NIT, my lord.
It's not imperative anymore. It just be L1. You know that very well. The law changed.
But well, there must be some reasonable basis for that, my lord. Where their tender document says blacklisting is different from debarment.
I can't deal with BCITS, which has got such a bad reputation.
Which one?
BCITS, my lord. Your lordship has, and smart metering, my lord. It's a smart metering,
but the contract volume is huge. It's 500 crores.
No, your lordship. That is what I was getting. If your lordship will see, it's a billed they will invest money. They will invest money. And this is for, if you look, kindly see page 58. What I was also under impression that there is nothing, nowhere. If your lordship will say it's a design, build, finance, own, operate and transfer. Everything is to be done by them.
Okay, it's not a simple,
it's a design. That's why they gave the figure. I was also surprised. So then design, build, finance, and nowhere they say in the written that this is and financial bid also there is no amount quoted by them. It is on record, my lord. I was also surprised. It's a design, build, finance, everything they have to.
List for further hearing on next part. Because interesting point also. I mean, even for academic purposes. You know.
But only, my lord, if they could maintain a status quo till then.
Your lordship has given the interim order. Interim order, your lordship may not, because
if they award the contract, my lord,
it's a public interest.
As learned,
I would not have insisted.
As the learned AG submitted, my lord, they are negotiating with L2, my lord.
Whatever is there, I can't, because had you not been blacklisted, there would not.
Once they award, you file. Then that time we'll see.
Matter is already parted. They should be respectful towards that one.
Grateful. I thought that 5 minutes, I think General will convince me, but he could not in 5 minutes.
Before vacation, new year will hopefully bring a new thought.
Yes, Mr. Khan.
In this case, we are yet to receive instruction, my lord.
What's the matter about?
It's RCW, your lordship.
You file affidavit then?
We are yet to receive the instruction. We'll file it.
Doesn't matter if file. Further time as period of 2 weeks allowed to the respondent to file affidavit.
32.
Obliged.
Other plan. Yes.
This is your lordship. Lordship, we need some more time, your lordship, for the affidavit.
But my lord, then interim order may continue.
Yes, Mr. N. Shulai, AG, please allow further time. Please allow further time, 2 weeks for affidavit. Please allow this after vacations. Interim orders pass earlier will continue till next day.
Next item, same, your lordship.
33.
Same. Apply, your lordship.
34. 34.
Is together or a transfer? Same matter.
Transfer.
Yes, Lord.
You serve copy of affidavit?
Yes, Your Lordship, I've already served.
MS Alima submits that. Copy of the affidavit. Find the other transfer petitions have been served all councils. This matter together for hearing with the other similarly situated matters.
Master.
Obliged, Lordship.